Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. It is a holiday week, so early happy Thanksgiving to all of you. That means that the courts will probably be weird. Holidays do weird things to the courts, so we'll have to just see what we have this week to work with and what we'll stumble across. But one thing that never stops is Miami-Dade, so let's start our week there.
From Lee County, Florida, the warrant was issued September 9th of 2008. So it's 17 years old. Yeah, almost 17 violation of probation. Guess you should have went down to court sooner. No bond on the warrant. Do you have any money to pay for a lawyer, sir?
If I could access my money, I could, but I got stopped on a plane and I have no access to anything.
Well, do you own your home?
Pardon me?
Do you own a home?
No.
Do you have a job?
Yes.
How much? Do you have any money in the bank that could be used to pay for a lawyer?
If I could get out my money, yes.
Okay, so I'm not appointing the public defender's office for you. Lee County has up to 15 days to pick you up. The reset date here is December 9th to make sure you get transported. And if for any reason you hire a lawyer and that lawyer is able to get Lee County to agree to a bond, then they can pop in on my Zoom here and let us know, and we'll give them a sample order. Okay?
Okay.
Thank you. I'd love to, sir. I'm sorry about that. All right. Next we have Quintus Lee. Yes.
Looking
What?
this warrant, and it says ROR and it has conditions, so I'm not sure what's going on.
Got to deal with it, Broward. So, sir, come on down, Mr. Lee. Is that Mr. Lee? No, where's Mr. Lee?
Leaves a Metro West, you are?
Okay, he's not here, so I got to pass it for him. Christian Henry? Mr. Henry there?
Leaves a Metro West as well, Your Honor.
Okay, he's not here yet, so it's got two. When are they going to corrections? Is Captain Eber there? We're trying to get misdemeanor judge to do these warrants. I'm looking for Captain Eber.
He works out of the REG building.
Okay, I'm going to find him. Derek Wilfong. Good morning, sir. You have an arrest warrant for Broward County. You owe child support. The writ of bodily attachment was issued on April 10th of 2025. I will appoint the public defender's office for you. Your cash purge is $607. So if you can pay that, do that in the jail in Miami, you get out quicker. If you don't have any money to pay that cash purge, you'll have to wait up to 15 days for Broward County to pick you up. The reset date here is December 9th to make sure you either paid it or were transported to Broward. Have a nice day.
All right, thank you.
Thank you. Rodney Holmes is next.
Your Honor.
Yes.
Hi, this is Officer Ali from Metro West. Lee Quinton and Henry Christian, they're both in the clinic. I had called earlier to notify bond hearing.
Oh, okay. Sure. I can reset them both for tomorrow. Is that what you want,
Yes,
Mr. West?
yes, ma'am.
Yeah, let's reset. Thank you. We'll reset
You're welcome.
Quintus Lee and Christian Henry for tomorrow.
Yes, ma'am.
Thank you. It's 11:25.
Thank you.
All right. One sec. Right now, this is Rodney Holmes. Good morning, sir. You have an arrest warrant from Broward County. The warrant was issued November 7th of 2025. The charge is battery. I will appoint the public defender's office for you. Unfortunately, there is no bond and you'll have to wait up to 15 days for Broward County to pick you up. The reset date here is December 9th to make sure you get transported there. They usually come once a week. You'll probably go sometime this week. Good luck to you. Next is Michael Estevez Aguilar.
Your Honor, I need a Spanish interpreter.
Good morning, sir. Spanish, please. You have an arrest warrant in Leon County, Florida. The warrant was issued on April 6th of 2023.
Muy bien, señor, buenos días. Usted tiene una orden de captura y arresto del condado Lee en Florida que fue emitida el 6 de abril del
The
2023.
charge is failure to appear in court for a non-moving traffic violation.
A usted se le imputa no haber comparecido ante el tribunal para responder a un citatorio de tránsito.
I will appoint the public defender's office for you.
Voy a asignarle la oficina de la Defensoría Pública para que lo represente.
There is no bond on the warrant. You're going to have to wait up to 15 days for Leon County to pick you up.
No hay fianza para esta orden de captura en su contra, así que va a tener que esperar hasta 15 días para que le vengan a recoger.
Your case is reset here December 9th to make sure you get transported.
Vamos a reagendar su audiencia para el 9 de diciembre para asegurarnos que usted haya sido transportado.
Sir, did you have a question?
¿Usted tiene una pregunta?
Y sí, el
Yes, I do.
yo pagué yo terminé con ellos hace un año, pues esa fue en 2023. Ya esta es la segunda vez que soy arrestado por la misma cada vez que salgo del país, no me sale aquí ya en el sistema aquí ya. Eso es un error del sistema porque es la segunda vez que soy arrestado por la misma multa, ¿sabes?
Listo. Okay. I already dealt with this issue. The thing is that somehow this is the second time that I'm arrested every time I try to go out of the country. So there is an issue, there is a glitch with the system.
You need to speak to the judge in Leon County, but they'll pick you up within 15 days, so you'll be able to speak to them and find out what that keeps happening.
Vale, usted va a tener que hablar directamente con el juez encargado en el otro condado para ver por qué esto sigue sucediendo, pero como le digo, va a tener que esperar hasta 15 días.
Have a nice day.
Que tenga buen día.
I'm done with this. I got one for the afternoon, so I'll keep it. Okay, what am I calling first? Corrections?
Yes, please, Your Honor. Can we have the articles?
What? What do you want?
Mr. Miller, Trey Miller.
Trey Miller, got it. Trey Miller is on the first case on page 16. Who's here for the public defender? Who's covering Miss Corey today? I saw an attorney here.
Judge, I'm just letting you know when you're ready. I have two officers.
Thank you.
present.
They're gonna have.
Yes, good morning.
Where's the? Are you at the jail? Miss Hill, are you at the jail?
Good morning. Assistant Public Defender Emily Howe.
Okay, good morning, Emily Hill. All right, I need Mr. Trey Miller. Come on in, sir. Good morning. Sir, you were arrested. He's on page 16. Sir, you were arrested for aggravated assault with a deadly weapon. This is a case from November 21st. I will appoint the public defender's office for you. So he stabbed it with his girlfriend or somebody's girlfriend. All right, there's probable cause for the charge. You were ordered to stay away from the victim, Jaquan Hopkins. One sec. With the victim?
No, I have my own placement.
And you don't have any children with the victim, right?
No.
All right, so no contact with Jaquan Hopkins, the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim's home, school, and place of employment at all times. Do you understand? Stay away order.
Yes, sir. Yes, ma'am.
All right. I have an objection to house arrest. Do you have any priors?
Yeah.
No.
All right. How can you house arrest with a GPS monitor?
Yes.
Alternate bonds will be $5,000. Level 3 house arrest. So I'm giving you a curfew though, 11 p.m. to 6 a.m. Stay away from the victim. You understand the stay away order?
Yes.
Okay. Have a nice day.
All right, good morning once again, everybody. Happy Monday. Welcome to the Courtroom Files Live. It's good to have you here. Let's switch gears. We'll stay in Florida, but check in with Wade Mercer.
Is in the courtroom. You're here because you've been accused of one count of battery and a petty theft. Now, you were first appeared this weekend. The judge found probable cause, and the judge set a bond in those cases. The reason that you brought back up today is that there was an indefinite hold on the VOP, and what we do in Jackson County is we do a 7-day hold. So what that means, Mr. Griffey, is I'm going to change that indefinite hold to 7 days. I'm going to put a time limit on how long they're going to hold you without a warrant being issued in the VOP. So I'm going to ask Mr. Mitchell to notify the state attorney, the probation office of the arrest. They have 7 days to we'll see if they get a warrant or not within 7 days, Mr. Griffey. So I'll see you again next Monday. If they have a warrant, the judge that signs the warrant will be the person to decide if there's going to be a bond on it or not. If they don't have a warrant, I'm going to release the VOP hold, and you would then be free to post a bond that the judge set for you this weekend. Mr. Griffey, do you have any questions?
No, sir.
Mr. McDaniel, the young lady in the courtroom said that she has evidence that the alleged victim in this case still has her phone. So, ma'am.
If you read the complaint, it's a pretty weak complaint. I mean, I don't doubt that would be it.
Yeah, I don't know what the Judge Garcia will do as far as whether she'll put a bond on this or not. That'll be her call. But it's 2 misdemeanors he's accused of. So do you want her to get that information to you, Mr. McDaniel, or do you want to get it to Mr. Green?
She can get it to me. That's fine. Just go to the office and ask for assistance and take whatever.
Ma'am, the Public Attorney's office is right behind the courthouse. Mr. McDaniel's assistant's name's Sissy Toole. If you take what you've got back there and ask to speak to Miss Toole, she can see what you've got, make a copy of it or whatever. But Mr. McDaniel will be his attorney in the misdemeanor cases unless he hires somebody. He may have a different attorney in the VOP cases. Okay.
The question is, if I can prove that he didn't take this girl's phone, will he not be violated on his probation?
So let's say that you get that to Mr. McDaniel. Mr. McDaniel will look at it, and if he thinks it's helpful, Mr. McDaniel will get up with Mr. Mitchell here. Mr. Mitchell is the prosecutor in the new charges and the VOP. So if Mr. Mitchell says, Judge, I have doubts about whether or not he committed this crime, there's 2 crimes now. There's the 2 charges he's accused of. One's a battery, one's a petty theft. If the state's not going forward with it, or if the state's not opposed to some kind of release and he gets out of jail. So the first step is get Mr. McDaniel the evidence you have. Okay? All right. Thank you, ma'am. Mr. Griffey, we'll see you in 1 week, if not before then. Let's go back to the top of the docket then. Mr. McDaniel, that's everybody in the courtroom. The first case on the docket is Brian Cass. Mr. Cass, good morning. Mr. Cass, you're here for first appearance accused of 1 count of refusal to submit to testing, breathalyzer or testing that is, and 1 count of driving under the influence. Mr. Cass, there is probable cause for these charges. Mr. Cass, I looked at your criminal history. I think I counted this as the 4th DUI arrest, although you only have 1 conviction for DUI, 1 conviction for reckless driving, where it was reduced, and the last case was a jury trial that was a not guilty verdict. So, Mr. Cass, I think you're entitled to a bond, but I'm going to appoint the Public Attorney's Office to represent you. Let's see what Mr. McDaniel has to offer, and we'll go from there.
Your Honor, I spoke with Mr. Cass, and I think that first DUI was, I think it was back in the 90s, so it was well outside of 10 years. We're going to enter a plea of no contest to the charge of DUI. The state's going to hopefully dismiss the refusal charge. $1,078 in fines. We're just going to ask the court to sentence him. He has 2 days jail credit, and he is local in basically Alford area. He's gets a disability check. He's used to work, but now he's disabled, and he just gets a disability check, and we just ask the court to sentence him.
So there's no agreed upon plea agreement, Mr. McDaniel, is that correct?
Correct.
Okay. Mr. Mitchell, anything before I accept the plea?
If he does plead to the DUI, the state will move to dismiss the refusal charge. That's all I can say.
Mr. Cass, I need to place you under oath and make sure this is what you want to do. Let me get you to raise your right hand, sir. Mr. Cass, do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Thank you. Mr. Cass, you understand that you have the right, you're accused of 1 count of DUI. The state's going to dismiss the other charge of refusal if you enter this plea. Mr. Cass, you understand you've got the right to go to trial, but if you enter this plea, there will not be a trial. You'll be waiving that right, And when you waive the right to trial, you're also waiving your right to call and cross-examine witnesses. Do you understand all of that, Mr. Cass?
Yes, sir.
Okay. The other thing I've got to explain to you is the maximum penalty for this charge, because he actually has one DUI conviction. This would be a charge that carries a maximum of 9 months.
Yeah.
9 months in jail is the maximum. I'm not saying you're going to get that at all. I'm just have to make you aware of the maximum. And the recommended disposition this morning was what?
30 days. Possible.
So that was the recommended disposition, Mr. Cass. Obviously, I would listen to you and Mr. McDaniel and Mr. Mitchell before deciding what sentence to impose. Mr. Cass, do you understand that you're waiving those rights, and is this still the plea you would like to enter?
Yes.
Mr. Cass, I'm going to accept your plea of no contest to the charge of driving under the influence. I want to find it's freely and voluntarily entered with the advice of counsel. So I'm ready to proceed to sentencing. Mr. McDaniel, do you want me to hear from Mr. Cass or you, or do you want me to hear from Mr. Mitchell first?
You just, whatever your honor wants to ask Mr. Cass. I mean, he's a good citizen. He just, he works in there. Well, he's disabled now. So, but he still lives in the area in Alford, and
Mr. Cass, I know you're retired or disabled from corrections, but I don't know if it was federal or state. Frankly, I can't remember. I think it's federal.
State.
Okay, you were in the state retirement system or state correction system for many years. So what I looked at this morning was I show a DUI several years ago, as Mr. McDaniel mentioned. The second one I think was in Bay County, and that one went to a jury trial, and that was, you were found not guilty, correct?
Yes, sir.
And the third one was within the last 2 years, and that one the state reduced to reckless driving or reckless driving with alcohol. Is that correct?
Yes, sir.
And that's all the criminal history I saw. Do you have any other criminal history besides those?
No, sir.
Okay. Mr. Cass, anything else you want to tell me about this specific incident or about yourself in general that you want to make sure I know for sentencing purposes?
Wrong place at the wrong time, sir.
Okay. All right. Thank you, Mr. Cass. Mr. McDaniel, anything else on behalf of Mr. Cass before I hear from Mr. Mitchell?
No, Your Honor.
And Mr. Jake Mitchell.
How long ago was his conviction for the DUI?
The actual DUI conviction was back in 98 in Calhoun County.
So there has been some time.
And the other one that was reduced to reckless driving, which I know nothing about other than it was reduced, was 22. So that would have been 3 years ago.
I mean, I know there was mentions that he may be a probation candidate, but some possible jail time may be needed given that he has a DUI and a reckless with alcohol on his record. If it was me, I would have probably made a probation offer if this went to arraignment. If the court's so inclined to sentence him to probation with maybe 10 days jail or something shorter than that. That way he can get out and start probation afterwards. That's what my recommended disposition would be.
Okay. So Mr. Cass, I'm not taking into account the one that was dismissed. I'm going to take that. The one that was not guilty. That's not a factor at all because it was dismissed. And the old one has very limited value. The one from 2022 has more value. And I was kind of thinking along the same lines as Mr. Mitchell. What I'm going to do is sentence you to 11 months and 29 days probation with the conditions you spend 10 days in Jackson County Jail simply because you had a DUI in 2022 that was reduced. So it's a 10-day jail sentence. That's part of your regular probation. You'll have the standard conditions of probation. Plus you'll have the special conditions required by Florida statute for DUIs. And those are court costs and fines. Mr. Mitchell, any objection to the imposition of the standard first offender court costs and fines like we normally do?
No objection.
So court costs and fines set by state law are very high. Even the first offense is high. So typically Mr. Mitchell will agree or even ask for first offender court costs and fines. And those are $1,077.
78.
$1,078 court costs and fines. Does community service change on the second DUI? Is it 50 or is it more than 50?
50 is mandatory, and it's up to the prosecutor and I guess the court if they want to impose more at that point. It can go up to 100.
What's your position on amount of community service?
I have no objection, just keeping it the mandatory 50.
Based upon the other one being so old?
Yeah, and he's going to be serving a little bit in jail, so he may be able to work some of it off there.
50 hours of public service work, Mr. Cass. I do. Say again, sir.
Oh, nothing. I was talking to him.
Okay. 50 hours of public service work. The standard DUI school will actually be level 2 DUI school because he does have a prior. The state's going to make him go to level 2 DUI school. and possible early termination of probation, Mr. Cass. That means you may be able to get off early if you get everything done early. And what am I forgetting? Recommended, I'm going to require the standard DUI counseling. It's at least 12 classes, but if you do the DUI school, that's going to satisfy your counseling because the DUI school is 16 hours. So that would be the equivalent of 16 classes right there. So if you enroll in that within 60 days, that will satisfy your counseling requirements. Mr. Mitchell, have I missed anything as far as the required conditions?
The minimum driver's license suspension.
I do recommend them a minimum driver's license suspension. Department of Highway Safety and Motor Vehicles will determine what that's going to be. But since the refusal is dismissed, I don't know what they'll do with that. A refusal suspension is different than a driver's license suspension. So you may have the right to go to administrative hearing and contest that refusal suspension. Lastly, credit for time served. Was he arrested yesterday, Mr. McDaniel?
He was arrested Friday night. So he's got 2 days jail credit.
Well, if he was arrested Friday night, he's already been to first appearance, which means he would have a first appearance bond already set. Corporal?
They didn't book him in until like 7 o'clock in the morning, but he got, it was about 7 o'clock before they booked him in, so they didn't go to first appearance.
Yeah, he was arrested really late Friday night.
Late Friday night.
Okay, so why wouldn't he have come to first appearance Sunday then?
Or I'm 2 days credit, so it's late Saturday night then. So Saturday and Sunday is what I'm saying. So I'm sorry, it's 2 days credit.
That makes sense to me. 2 days credit, Mr. Cass. So Mr. Cass, what we're going to do is I don't want you to have to come to the probation office to get instructed when you finish the 10 days. I want to go ahead and get that out of the way. That way, when you do get out and you finish the 10 days, you're just going to be released and then you'd start reporting the next month. So what we're going to do is I'm going to ask the jail to bring you to the courthouse after first appearance today. Mr. Ham will go ahead and get you instructed on the terms of probation. You'll go back to the jail. You will finish the 10 days, but you have 8 days left. You certainly may do less than 8 days, Mr. Cass. And Mr. Cass, when you finish that 8 days you have left, you'll be released on probation. You won't have to report in until the next reporting period because you've already been instructed on probation. So we'll do it that way, Mr. Cass. That way we get your instruction part out of the way. Mr. Ham, have I missed anything? Mr. Cass, do you have any questions, sir?
Judge, would you consider maybe a five-day releasing Wednesday and coming back maybe the following Monday for the remaining 5 days?
Say that again.
Would you consider letting him do 5 days in credit? That means he'll get out Wednesday and then he'll come back the following Monday. For
because of the holiday?
Days. Correct.
Yeah, I didn't think about that. Mr. Mitchell, what's your thoughts about that?
I didn't either. I have no objection to it.
Mr. Cass, would you like that opportunity to spend the holidays with your family and then come back and finish it later? Or would you prefer just to do it straight and get it done?
That would be nice, sir.
Yeah, I don't have a problem with that. You just need to understand you can't drive during the 5 days.
Yes, sir.
And you can't possess or consume alcohol, Mr. Cass, during that
Yes,
5
sir.
days. So what we're going to do is direct that Mr. Cass, we're going to direct that you be released on Wednesday morning. Why don't we say 9 a.m. Whatever time jail, jail corporal, whatever time y'all normally release people, 8 a.m., 9 a.m., whatever time it normally is. And Mr. McDaniel, come back when? What's your suggestion?
Monday's okay. Monday will be fine, Your Honor. Just come back Monday and.
Mr. Mitchell?
No objection.
And report back to the jail at that same time. So if you get out at 8 a.m. Wednesday, you'll be back at 8 a.m. Monday, Mr. Cass, to finish the sentence. That way you spend the holiday with your family if you wish. So they'll still get you instructed today. Madam Clerk? Yes, I have to adjudicate him guilty under state law.
Mm-hmm.
All right. Mr. Cass, I wish you the best, sir. And you'll see Mr. Ham at the courthouse in just.
One other question, I guess county probation is not allowed to, they're allowed to have guns, aren't they? I guess over the hunting weekend.
Absolutely. We don't, there's no restrictions on a misdemeanor on possessing firearms, Mr. Cass. Okay. All right. Have a good day, sir. After Mr. Cass, we have Brendan McCardle.
Keep those priorities straight. Make sure they can hunt on Thanksgiving.
Mr. McCardle, good morning. Mr. McCardle, you're here because you've been accused of violating the terms of your county probation in case 24-504 CT. Mr. McCardle, I'm going to appoint the public defender's officer to represent you. I'm going to ask you to listen to Mr. McDaniel, your attorney, sir.
Your Honor, I spoke to Mr. McCardle and the case number. He's going to admit that he violated his probation. He has 4 days jail credit, and I'm just going to ask the court to sentence him.
Mr. Mitchell, let me see if let me get the plea on the record first, Mr. Mitchell, and then we'll see what your position is. Mr. McCardle, let me get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. McCardle, you understand you're accused of violating your probation and you have the right to go to a violation of probation hearing. Mr. McCall, if you go to that hearing, the state will try to prove that you violated the terms of your probation. You have the right to have an attorney represent you at that hearing. Most likely will be Mr. McDaniel. We'll see if they can prove the allegations against you or not. I don't know if they can or not, but you have the right to that hearing, and you have the right to call and cross-examine the witnesses at that hearing. But if you enter this admission that you violated the terms of your probation, there will not be a hearing. And I'll listen to you. I'll listen to Mr. McDaniel, like you just saw me do with Mr. Cass. I'll listen to Mr. Mitchell, and I'll decide what sentence to impose based upon that. Knowing all of that, do you want to admit you violated your probation and waive your right to a hearing?
I mean, no, sir. I don't believe so. I don't know. I don't know. I don't understand all.
If he has questions, we can see him tomorrow, Mr. McDaniel. We've got a funeral this morning that I've got to get to. So there's nothing wrong with him having questions, but I may need to do that, ask questions off the record. And
I will say, if we proceed to sentencing, I don't really have nothing to say towards this. So,
Mr. McCall, it's up to you. If you want to admit you have violated probation, I'll listen to you and I'll sentence. But you are waiving those rights. I've got to make that clear on the record. Any questions?
No, sir. I just talked to Goodson Monday.
Do you want to? I'm just going to show a plea of not guilty. I'm sorry. I don't have time to go through this morning. So we're going to show a plea of not guilty. You're going to be held with no bond. I'll see him again tomorrow, Mr. McCall. If you want to resolve it tomorrow, I'll see you again tomorrow.
No, you were saying I was going to say I need to go and do it today so I can get on the holidays. Like my little boy, I've always got for Christmas.
You're not getting out in the holidays, regardless. You're not going anywhere. You're accused of violating probation on a DUI, so you're not getting out in the holidays, regardless. So I'll see you in the morning, Mr. McCardle, and we won't be rushed. Give you plenty of time to talk to your attorney. I'll see you in the morning, sir. Next, we have Jaleel McSwain. Mr. McSwain, good morning, Mr. McSwain. You're here accused of one count of possession with intent to distribute. That actually, the officer didn't put it on the complaint, but that is marijuana is the charge, which is important because that's a third-degree felony, not a second degree like some other substances would be. You're also accused of possession of firearm during commission of a felony. That's what the complaint says, but that's not what the statute says. What the statute says is carrying a firearm during the commission of a felony. So let me hear from the state and defense on that second issue on probable cause. Mr. McDaniel, what's your thoughts?
I looked it up. I don't think the state's going to object to it. There's no probable cause for it. Is that correct, Jake?
Yeah, I think it's just more carrying or something.
So, Mr. McSwain, there's this crime called carrying a firearm in commission of a felony. The officers use that statute number. There is no crime possessing, and here's the difference. Carrying typically means on or about your body. It actually means on your body or in your pocket. Possession can be constructive possession, which can be in the back seat, could be, as long as you have control over it, you may not be carrying it, but you can still be possessing it, what's called constructive possession in Florida. So the state and defense are in agreement. There's no probable cause for carrying a firearm because there's no allegations you were carrying it. There are allegations it may have been in the vehicle, which could be possession, but that's not the same. So on that second charge, there's no probable cause. I'm going to find no probable cause. You don't have to post a bond. On the first charge, possession with intent to distribute, there is probable cause based upon the number and the manner of packaging of the alleged substance. So in that case, I'm going to find probable cause. Mr. McSwain, I show no prior criminal history, which is great. Is that accurate? Have you ever been charged with a crime anywhere?
No, sir.
Okay, let me listen to the attorneys, and I'm going to set you a bond or give you some other kind of release option. Mr. McDaniel, anything on behalf of Mr. McSwain?
No, Your Honor.
Mr. Mitchell?
No matter what kind of release option he gets, we just request that he be subject to random UAs.
Mr. McSwain, I'm not going to give you a conditional release because of the intent to sell, but I'm also not going to set you a normal third-degree felony bond. I'm going to set a little bit lower bond because your history is so good. If it was just regular possession, it'd be different. But allegedly, you're possessing 15 separate packages of marijuana. I'm going to set your bond at $2,500 cash or surety. Cash or surety means you can go through a bondsman, Mr. McSwain. If you go through a bondsman and they charge you 10%, that means it'd be $250 is what it would cost to get out of jail. Mr. McSwain, you'll get to use the phone in a few minutes, sir, to try to post the bond. And you also will have a condition of random urinalysis because it's a drug offense. Mr. McSwain, if you don't post that bond today, I'm going to ask the jail to put you back on the list for tomorrow. so I can take a closer look at it, but hopefully you post the bond today and get out. You do have no history, so if you're still there tomorrow, I'll see you again tomorrow. You have any questions?
You said how much was the 10%?
If you go through a bondsman, and if they charge you 10%, that's $250.
250. Okay, yeah, so I'll get that posted today.
All right, wish you the best. Or lastly, we'll give you notice for your court date, Mr. McSwain. For felony court, that would be, today is the cutoff for the docket. So you're going to make the December docket, December 2nd at 8:30 a.m. So Corporal, if we can give him a notice for December 2nd at 8:30 a.m., please. Mr. McSwain, they'll give you that notice before you leave the jail. Wish you the best, sir.
Your Honor, I guess for purposes of clarity, should we just list the firearm charge as an ROR for bond purposes?
Yes, yes,
Okay.
and no probable cause to be an ROR. Thank you. And it's carrying. I know that the officer put possession in the complaint. There is no crime of possession of firearm under those circumstances. The statute doesn't say possession anywhere. You know what, though? What I found when I researched that this morning, Mr. McDaniel, Mr. Mitchell, I found a case from the first TCA that basically said that every appellate court in Florida has used the word possession also, talking about that statute. So
I seen one where basically it was in a bag and, they said that's not possessing it where it was in a bag. And his was in open, it was an open, it wasn't even concealed because it's an open, because he told him about it and it's sitting there in the side compartment. You can clearly see it in the side compartment. It's an open compartment. So it's not, it's not, I didn't think it come anywhere close to anything statute.
The recent first TCA case makes it a little even muddier, I guess. So Mr. McDaniel, it's everything I had this morning that I'm aware of. Anything else from the public defender's office?
The only thing I had about that was, I know you said between $500 bond, but I mean, a third degree possession of marijuana is, possession is a third degree felony. Intent to distribute, that wouldn't be a second degree felony?
No, it moves it up 1 degree. So it comes from a first degree misdemeanor. So possession over 20 grams and possession with intent to distribute marijuana are the same degree, third degree. But the complaint just says possession with intent to distribute. He doesn't name the drug. That's why it's important to note that it's marijuana, because if it was cocaine or methamphetamine, it would be a second degrry, but marijuana is third.
Okay. Yeah, I just didn't look that up. And I figured he said that bond. McCardle, I don't want to tell you about him. He's slow. I mean, let me take it off. Wait till we get off YouTube.
We'll see him tomorrow and we'll see if we fit. But the reason I let Mr. Cass out for Thanksgiving is, number one, it was a 10-day sentence and he's going to have done half of it, but it's not a VOP. And I view that differently. So you may convince me to let him out for Thanksgiving, but
I wasn't going to convince anything. I think just he turned himself in because he said Stacy told him he was probably going to get a purge. And he's trying to tell me what Stacy said he would get a purge. And I said, no, Stacy would never tell you that you're going to. He said there's a possible,
If it was financial only, then I certainly may consider that. But the complaint doesn't allege financial only. The complaint alleges he also didn't do counseling. He didn't do counseling.
So service, but that could be bought out.
Or community service. So we'll listen to tomorrow and listen to Mr. Ham has some additional information too. So where do we stand on the list for early releases? Have you got that or possible early releases?
Not gotten it yet.
Sarge,
we don't have any.
Corporal?
We don't have
There
any,
aren't
sir.
any? Perfect.
No, sir.
All right. Anything else on the record, Corporal?
No, sir, not that I know of.
Mr. Mitchell?
Nothing from the state, Your Honor.
Mr. McDaniel already said he didn't have anything else. Ladies and gentlemen, that concludes first appearances for today. It's 8:57 and first appearance court is adjourned. So don't disconnect. Just go.
Okie dokie, friends. That's Wade Mercer for today. Let's go up to Michigan. Let's see what's going on with Judge McNally.
Thank you. M. Patrick Argoshen, 25B149463. Good morning, sir. Your name? Your name, please?
William Nicholson.
All right. So this is a plea of impeding. Again, no functional damage with this. No injuries, minor damage, I should say. So to that charge, responsible or not responsible to impeding traffic?
Responsible.
Plea is accepted. Original charge dismissed. 195. You're all set down the hall. Thank you. Ashley Lauren Donawika. 25B149396. Good morning. Your name? So they offered you impeding, but you don't want impeding, right? Right?
Correct.
Okay, so I'm not trying to talk you out of taking their deal. I could care less. If we set it for informal and you lose, though, the conviction's going to enter and you're going to be assessed 2 points. If you plead to impeding, it's 0 points. That's essentially they're offering you a plea bargain. So I just want to make sure that this is what you want to do.
It won't be still open if I go to court.
No, because
Oh, that's clear.
I mean, if you go to a hearing and that's what you're asking, right? You lose, the conviction's going to enter.
I was told that it would be the option for the hearing would still be there.
You mean if you have a hearing and lose? Who told you that? Did you handle this one?
That is correct, Aaron.
Your name?
Officer Blaze Bob Brown.
I just want to make sure you understand this. You don't kind of get to have the best of both worlds. You follow me? If you go to a hearing and you lose, the conviction's going to enter. If you plead to impeding, it's 0 points. It's not going to go on your record. Again, I'm not trying to talk you into it, talk you out of it. I could care less. But you can't go to a hearing, lose, and then say I want impeding. It doesn't work that way. Pardon? So what do you want to do? Okay. Are you sure?
I could write it for impeding your ass.
Are you sure that's what you want to do? I'm not trying to talk you out of it in any way. I want you to know that. So pardon?
Is that okay?
Well, why don't you go talk to him further and you guys can figure it out? How's that? And he'll write it up if things change, okay? All right, good luck. Dennis Fell, 25T 646-831, and then either way, you need to come back in front of me, ma'am, okay? Your name, sir?
Dennis Fell.
Okay, you're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible for that?
Responsible.
Okay. 160 is your total. Please accept it. You're all set. You can go down the hall and take care of that.
Thank you.
Have a good day.
$160.
Tiffany Jones. 25T646-921. Good morning, ma'am. Your name? All right, so you're going to plead responsible to impeding traffic, correct?
Correct.
Responsible or not responsible to that?
Responsible.
I'll accept the plea, dismiss the original charge. 160 is your total. You can go down the hall and pay that. You're all set. Good luck. Thank you. Same to you. Thank you. Okay. Randy Reba, 25T646-935. And could I have Kevin Greenley seated at the table up here and Antoine Thompson and Matthew Shutt? Your name, sir?
Ray Riva.
All right, Mr. Ryba, you're going to plead responsible to impeding traffic, correct?
Yes, sir.
Responsible or not responsible to that?
Responsible.
Okay, I'm gonna accept your plea. 150 is your total. You can go right down the end of the home. You're all set. Good luck. Thank you. Kevin Charles Greenley, 25T646-803. A and B. All right, your name?
Kevin Lee.
So am I right that you're going to plead to both no proof of insurance and seatbelt violation?
Correct.
All right, to the charge, no proof of insurance, responsible or not responsible?
Responsible.
To the charge of seatbelt violation, responsible or not responsible?
Responsible.
All right, do you have insurance now?
Yes.
Can I see it? This was a 1998 Jeep.
Jeep Grand Cherokee.
Right. Does it show that you had insurance on it? Let me see it.
Effective date is actually on the birthday.
October what? 20th?
Yes.
Okay. All right. So I'm gonna
6 days after.
I'm gonna cut that down a little bit for you. I'll make it 125 on the no insurance, 65 on the seatbelt, okay? And you can take back your proofs there. Thank you. Thank you. Have a good day. Good luck. Antoine Demetrius Thompson, 25W840-608. Your name, sir?
Anton Thompson.
All right. Good morning to you, Mr. Thompson. You met with the department rep. Let's see what's going to happen here. You're going to plead to impeding traffic, true?
Yes.
Responsible or not responsible to that? Okay, I'm gonna accept the plea. 150 is your total. And you're all set. Cashier into the hall, down the hall there. Good luck. You're right. Thank you. Matthew Martin Shutt, P5W840418. Good morning, sir. Your name?
Matthew Martin Scott.
Okay. You're going to plead to impeding, right?
Correct.
Responsible or not responsible to that?
Responsible.
All right, and accept the plea. 150 is your total and you're all set. Have a good day.
Clearly traffic day today with Judge McNally. I suppose it's good to get those things cleared up before Black Friday, when everybody spends all of their money and they've got nothing left to pay their traffic tickets with. But speaking of Black Friday, I do want to point out the sponsor for this hour of the Courtroom Files Live morning show is the Courtroom Files itself. We have a lot of merch here, and we currently have a Black Friday sale going on. Everybody gets 15% off everything in the store. If you're a member, you get 25% off, and I've just made a post in the community tab for members to let you know what code to use for that. We have started to build out our Christmas collection. Got a very nice hoodie, a very nice long sleeve shirt, mug, a couple of ornaments, but what I'm especially proud of is our 2026 calendar. This is a first for the Courtroom Files. It is themed as street justice. There's unique artwork every single month for what that month's theme is. The calendar is wonderful. It is priced well just on its own. Plus, if you are not a member, you get 15% off. If you are a member, you get 25% off. So be sure to pick up one of those. I think it'd make an excellent gift as well. So be sure to check that out. Great way to support the channel, support what we do here. And you know what? It's Christmas time. You're going to spend money anyways. Do us a favor. Spend a little bit with us. Let's go to... Stay in the Detroit area. Let's go to Judge Mom, maybe? Yeah, Judge Mom.
Okay, and so today your client is here. He's walked in on the warrant that had been issued for his failure to appear back in 2023. Well, also 2024. And so, counsel?
Yeah, Your Honor, as to the failure to appear, warrant be set aside. It's unfortunate that we're going to state the other day. Otherwise, I would speak to a prosecutor, try to find an arrangement.
All right, the warrant's been recalled as to the arraignment, counsel.
As the arraignment wait from reading my client's statement.
Waive the formal reading, enter plea of not guilty for purposes of the arraignment. And then as to the pretrial date, we will schedule this for December 4th.
At 9:50.
At 9:15 a.m. Okay, and then as to bond counsel.
Your Honor, my client walked in voluntarily. He did not drive here today. His girlfriend drove him. She is in the car and willing to come in if that's going to be questioned. He is gainfully employed. He works at Happy's Pizza. He lives in Allen Park with his girlfriend. I believe he does have one child. He is currently in school. He's attempting to get his GED through Asher. He's cleared up all of his other warrants through Taylor and Detroit. Judge, he came in on his own volition. Obviously, it would have been better if he had taken care of it back at an earlier date, but it does seem that he's turned the corner. It does appear that he came here seriously. I'd ask consideration for a personal bond with a quick turnaround date of a pretrial so that he can get this matter resolved. Thank you, Judge.
All right, thank you. Well, Mr. De La Cruz, you lost some money already with bonds and you've failed to appear twice. One time on a walk-in warrant. Why don't you show up for court?
I just didn't realize I had court.
or I probably didn't have the money, honestly. I wasn't working when I called, and I think my bond was only like $400.
$400 isn't a lot of money, is that?
Just wasn't working at the time.
So was it, you didn't realize you had court or you weren't working?
I mean, I was working, but I didn't realize I didn't have court done.
Don't you have a calendar on your phone, sir?
Yeah, didn't even mark it down.
Right. Did you
Just
put it in,
take
did
care
you
of
do it this time?
Yeah. I'm gonna take care of
Okay.
it.
I need you to sign, can you have them fill this out, please? Yeah, it's in there, but it's not filled out. Where do you work now, sir?
For Happy Pizza, it's been on and off for like 4 years, but. So
What do you do for Happy's Pizza?
I cook, I answer phones, I clean, I prep, I do everything you want me to do.
Well, I want to make sure you're not delivering pizzas.
No.
No, he's not. Sorry.
You fill it all.
Fill that out. Write your name right there. Right there. Write your name. Write your name right here.
Oh, that's what I thought it was. Right?
Yep. Right here. Write your name. If you found the believe that.
Two one three 808-4701.
All right, thank you. And so, sir, you've been working there off and on for 4 years, so all this matter's been pending. And so what's different this time that you're able to come back to court?
I need to get my license. I ain't never had my license, so I'm trying to get it. I just gotta get my tickets cleared up in there. I'm eligible now.
All right, where else do you have tickets, sir?
It's all being cleared up.
That wasn't my question. I said, where else do you have tickets? Nowhere.
I mean, for Taylor on the payment plan in Detroit, but nowhere else besides that's being taken care of.
Okay. And so, you did not drive here today?
No, I do not.
And how do you get back and forth to work, sir?
My girl drops me off.
Are you still at the same address?
No, I recently moved it.
Okay, so sir, your attorney gave this to you to fill out. And you haphazardly filled it out. You seem to have an issue filling it out, and you didn't even put your address, so we know that you're going to get the accurate information if we have to send it to you.
And I'll take it and I'll get it filled out properly and have it put the court file.
Thank you. Are you currently on probation or parole anywhere, sir?
Yeah,
Where?
for Wayne County.
Okay, and so what is the charge?
It's a CCW.
And when are you off probation?
I was supposed to be off, but she said I had to take care of my tickets to be able to get off. Because I've been on it for 8 years.
You've been on probation for 8 years? That tells me that there is a warrant at some point for failure to appear for probation violation or something.
It was just violations. It was never, I always showed up to court.
Just violations.
Violations. My judge just worked it out for me, and it's all under item.
Okay, sir. Violations are violations. When you say just violations, you're minimizing what it is.
I mean, it was for beginning with fleeing and eluding, and then I called a CCW case. And then I just been on it for that.
So you're on probation for a felony fleeing and eluding, and then you got a CCW?
That got dismissed because I finished, but it's just CCW.
What do you mean it got dismissed because you finished?
Because I was on probation so long, they dismissed it. And just
Okay, so you pled guilty to felony fleeing and eluding?
Yes, I got charged for it.
Okay, and then you're on probation for it for a while?
And then I called a CCW case.
Right, okay, so you've been on probation for continuously 8 years for multiple different charges, not just for one charge. Okay, that makes a bit more sense. All right, well, how much money do you have to post today for bond, sir?
Honestly, it's kind of tight right now because I just got violated and I just paid this work deed. I'm just trying to do my stuff.
So I understand that. But the problem we have here is that you were to appear on May 11th of 23. You did not appear. We issued a warrant. You forfeited your bond. You walked in on May 15th of 2024. We set a date of July 2nd of 24. You once again failed to appear.
Yes.
And so now the court issued another warrant, and now you walked in today. So you seem to go every 15 months, you show up for the warrant that's been issued because you don't appear for court.
It's not that I need my license, so I don't have this problem.
Well, that's great. We need you to show up when we schedule you,
That's all.
and that doesn't happen. So now that you need your license, now you need to show up. That's what you're telling me?
I'm trying to get it taken care of. It's not just that. I got 3 kids. I only got one. I just had a newborn. Got an 8-year-old and a 4-year-old big little girl. I'm just trying to do the right thing around here, honestly.
Right.
It's just money tight. It's Christmas. It's Thanksgiving. I really don't have no extra. I gotta pay rent.
Right. That's why then I will make sure you're showing up. That's why I want to know. How much are you able to post today for bond?
I really only got like $20 in my pocket. I don't have no money.
Okay. What did your girlfriend have out in the car?
She didn't bring no money with her.
Well, sir, I'm going to order a $1,000 10% bond.
So that'd be $100.
Sure will be.
Can I pay that right now?
Of course. That's why I asked what you could pay.
All right, I'm gonna go in there and talk to us. And I'll be right back in.
Right. And no driving.
No driving.
Just let me just be very clear, sir. In the event you are arrested or pulled over or cited for driving while license suspended in any city, the court will revoke bond and you'll remain in jail until your next court date.
Understood. It's 1089, please.
I need somebody to walk out to the car with them so he can.
No, my address is my mom's still in Addison. So it's Addison, but I'm saying this is where
Sir, where do you live?
I've been talking about.
No, I need to know where you live.
It's 1089.
Okay, so you said something.
I said my ID, he didn't want to change it because it still says my mom's address, but it's not even changing it.
Why don't you change your address? Keep your hands out of your pockets, please.
I just didn't go do it. I'm gonna do it soon. I think I can go to Kroger's and just switch it over, can I? I should be able to.
Kroger? There's a Secretary of State in Kroger?
Yes.
Sir, I have no idea. I'm with the judicial branch, not the secretary, the legislative branch. I'm not with that branch. So I don't know what you can do or not do. What I do know is that you can post $100 or you're not going home.
Okay, I'll post $100.
So one of my court officers is going to walk out to your car with you.
Okay, that's fine.
So that we make sure you're coming back in.
No.
And we can also confirm that your girlfriend is out in the car. So, and that she did the driving.
Yes.
Okay. All right. Thank you. Have a good day. We are on the record in the matter of the City of Riverview versus William Honeycutt Jr., 251414 A and B.
Good morning, Your Honor. Mr. Shemke, appearing on my client approaches.
All right, thank you. Answer your name for the record, please.
Honeycutt.
Okay, so this is the adjourned date. You were arraigned on November 10th. And counsel,
We're still,
we adjourned it today for discovery.
Correct, Your Honor. We're still in possible negotiations. I have not received full discovery. I'm just gonna ask for a 2-week adjourn. I fully anticipate getting everything by that time. My client was here timely, he's been in violations.
You've not received all of the discovery?
No, Your Honor. There's some video discovery, I believe, that still might be outstanding. That's why I'm only gonna ask for a 2-week adjournment to the 8th. I'm back here, as is Mr. Carmen.
All right, we'll set for final pretrial November 8th. December 8th. You didn't even catch that, did you?
I was listening for it.
8:45 a.m. All right, bonding conditions are continued. Thank you. Have a good day.
Thank you, Your Honor.
We are on the record in the matter of the City of Riverview versus Robert Phillips, 251517.
Good morning, Eric. Mr. Sheppy here on behalf of my client who approaches against my road.
Okay, good morning, council. There's nothing filled out on this plea form. So I'm just gonna have you, Mr. Carmen, fill it out, please. Thank you. All right, let's go on the record in the matter of the State of Michigan versus Thomas Kimball Jr., 2511A.
And Your Honor, Leslie H. Cock, on behalf of Thomas Kimball, this is my right. Please see you.
Thank you. Miss Monday.
Thomas Kimball.
All right, good morning. All right, thank you. All right, and today's the date scheduled for sentencing on your client's plea to a very generous plea where the operating while intoxicated second offense was dismissed and your client pled to an operating while intoxicated first offense, and then the speeding 1 to 5 counts B and C were dismissed by way of resolution. And did you have an opportunity to speak to, or I'm sorry, to review the report and recommendation with your client?
I did, Your Honor. I did receive it. My client and I did review it. We have one small correction just to make note of this morning for the court, and this is an address change to my client.
Okay, did you notify probation, sir?
Yes, Your Honor. She told me to bring it up to you for,
The address change?
yeah, I believe she made the amendment after she said something about,
Is it Allen Park?
No, it's in
that was the previous address.
Okay, so sir, you're, okay. All right, I'll have you write it down on here, please. Terry, if you can give this to Mr. Kimball, so he can write down his address.
Thank you, Your Honor.
Okay.
And other than that, it is factually accurate. There are no errors or omissions.
All right, sir, when did you move to Allen Park?
Moved to,
Taylor.
the beginning of the month. So the first.
Thank you. All right, and so, the court will note this matter was originally scheduled for sentencing on October 6th. And then it was adjourned to October 21st. It was not held based upon a request to reevaluate with the 25th District Court for treatment court. And apparently that was favorable to your client, correct?
That is correct, Your Honor. It has been accepted in the program pending today's sentencing.
All right, sir, if you were to test right now, what's in your system?
Nothing, Your Honor.
And how have you been feeling?
Well,
All right, sir, I certainly hope that. Oh, wait a second. I certainly hope, sir, that you are going to utilize your opportunity in treatment court to focus on modifications so that this does not happen again. You're .211. And you have a prior, so you know at what point you're not okay to drive. You know that. And yet you still chose to put your lives of others at risk. It was your choice that day. The court will, actually, let me, and you and your client to both sign these, counsel. The court will order that you are to comply with all terms and conditions of the 25th District Court Sobriety Court. So I want you to be aware that that you have been given a very big opportunity here, sir.
Yeah, I'm extremely grateful to be able to use everything they give me just to help overall with my life and to go with the choices.
Okay.
And I've had the opportunity to discuss it with my client, and he has exhibited some real excitement to me regarding the program and the little taste he's had of it so far. And Judge Clifton, who administers the program over at the other courthouse, has indicated to me, you know, how comfortable he's feeling and how helpful it's been already. And he's looking forward to delving into more after today.
Okay. All right, and this will be a total transfer. Program fees for the 25th District Court are $1,080. The fines and costs of this quarter as follows: $500 fine, $100 screening assessment fee. There are not any oversight fees here because you're going to be supervised over at the 25th District Court. $300 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $1,025. So, sir, you did post a bond of $500 in this court. Do you have an additional $525 to pay today?
Yes, sure.
Okay, so then that way the fines and costs will be complete here, and then you'll just have your program fees to worry about at the 25th District Court.
Okay.
Okay?
Thank you, Rhonda.
Thank you, Hannah.
All right. Good luck to you, sir.
Thank you.
Thank you. Have a great rest of your week.
All right, thank you. You as well. All right, let's go on the record in the matter of the City of Riverview versus Alicia Trombley, 251307.
Morning, Your Honor. Record Leslie Acad. I'm the talking Ms. Trombley, who's present to my right. Can you please state your name for the court, Ms. Trombley?
All right, good morning. Today is the date scheduled for the adjourned pretrial in this matter. And counsel?
Your Honor, I had an opportunity to meet with the prosecutor and discuss the matter with my client. She is prepared to avail herself of the offer this morning, which is dismissal of the original charge of larceny in exchange for a guilty plea to disorderly conduct. And she's prepared to tender a factual basis that her behavior was disorderly on the date of this offense.
Okay, this does not address count two, so I need you to chat with Mr. Carmen again. The plea sheet doesn't address count two.
Oh, okay.
Okay. All right, thank you. And then we'll recall this matter. We're on the record in the matter of the City of Riverview versus Ishina Walker, 153311.
Good morning, that's Attorney Tori Westmont, appearing on behalf of Ms. Walker. Ms. Walker, would you please state your name for the record?
Ishina Walker.
I'm sorry, I don't think we picked that up.
Ishina Walker.
That come through?
Yes, this.
Oh, okay, thank you. All right. Yeah, I'm sorry, I didn't even make it on the bottom. I can't see it this time. Okay. All right, ma'am, just please keep your hands out of your pockets. And counsel, today is the date scheduled for the arraignment and pretrial in this matter. And ma'am, I do apologize for your wait today, although it was less time than we waited for you to come in and take care of this matter. So, counsel, as to the arraignment.
Yes, Your Honor, at this time, we are prepared to waive a formal reading. My client stands mute.
The court will waive the formal reading, enter plea of not guilty for purpose of the arraignment. And as to the pretrial, counsel.
Yes, Your Honor, at this time, we would be asking for an adjournment for discovery purposes.
For discovery purposes?
That's correct.
Okay, that's not what the plea form.
And negotiations.
Okay.
There really wasn't even a police report or incident report in the file.
To what?
There wasn't even really an incident report, and I'm not even sure that this court has proper jurisdiction over this matter. The incident alleged to have happened in Detroit.
In Detroit? Okay. All right, so we will set this for, you are back December 1st. That's 1 week. Well,
Sorry, Judge.
that, you're only back one Monday in December, and that's next week.
I think that would be enough time.
Would 2 weeks be enough time and Mr. Shemke can help you out, or?
I got the nod from Mr. Kempe. He'll be happy to.
Okay.
Help me with this.
Not even seeing there, okay. Yeah, 8:45. Yeah. Okay, as to bond.
Yes, Your Honor. Ms. Walker did appear here today. As soon as she learned about this warrant, she walked herself in, cleared herself, assured me she would be appearing all from court dates. He currently is getting employed full time at Bright Star. And did you post a bond?
No.
Okay, I would just ask for consideration for a personal bond on her behalf this time.
All right, other than this matter, ma'am, have you ever failed to appear in court for any reason?
No, ma'am.
And the address on your advice of rights is your current address?
Yes, ma'am.
And how long has it been since you've been at that address?
I've been at that address 7.5 years.
Okay, and how long has it been since you've been on the Fielding address?
What field and address?
That's the address we had for you, 18910.
I never lived there. I can name all the streets in Detroit that I live in.
Well, I don't even know where that number came from, that address came from, because the address in the report says Glastonbury. Did you live on Glastonbury?
And yes, ma'am, but the address they have in Glastonbury is not the correct address, and I can bring documentation to court for that.
Okay. Okay, I don't even know where these, addresses came from, but, you were notified of the warrant with your contact in 2003 with, or 2023 with Detroit?
No, ma'am.
And where do you work, ma'am?
I work part-time at Henry Ford Hospital, and I also work at Bright Star Home Care.
What do you do, part-time for the hospital?
Basically just a CNA job.
And is that at Henry Ford, Maine?
Yes, ma'am, on Grand River.
And so you don't know Miss Moore, correct?
I do know her. She used to be an old co-worker.
Oh, okay. And so you don't speak with her anymore, do you?
No, we stopped speaking like a couple years ago.
A couple as in 10 years ago?
Probably about 6 years ago.
Okay. All right. Okay, the court's going to order, are you out on bond in any other jurisdiction?
No, ma'am.
The court's going to order a $7,500 personal bond. You're not to have any contact with Miss Moore. That's phone contact, text message, email, social media, third party, anything of the like. And then just have a seat. You got a copy of your bond conditions, and then we'll see you back on the 8th. Okay.
Thank you, Judge.
Thank you. Have a good day.
It's the Courtroom Files live on a Monday. Happy Monday to all of you. Holiday week. So we'll see what the courts bring us. There's actually quite a bit of action today, probably trying to squeeze it in early so they can leave early. But we'll have stuff to show you all week long. It'll be good. Let's go back to Miami-Dade, checking on Judge Glazer. We have entered the witching hour over there now. Let's see how she's doing.
So, Ms. Sturgis, I have a question.
Yes, Your Honor.
Who said an F2 aggravated battery? Is that
I'm
because the
sorry.
firearm was used?
Can you repeat that? I'm sorry.
Why isn't it second-degree felony aggravated battery? It's charged with the first degree.
I think it's aggravated battery with serious harm. And then the weapon. So when you have the harm and the weapon, it goes from an F2 to an F1. Either or is the F2. Here we have both.
I don't know. The state wants me to find probable cause for her. She works as a nurse. He shot her son. Doesn't look like she wanted to hurt his son. He was going around shooting things up around her house. I don't know why she didn't call the police and get him Baker Acted. He could have killed somebody, and she wound up shooting him. And let's hope he's okay. I don't know what the state wants here. You filed a motion. You have an objection. The court finds an F2 aggravated battery.
I do at this point, Judge. I'd ask for it to be heard in division tomorrow, where perhaps with more information it can be adjusted accordingly. But at this point, with the facts we have in front of us, I'd be asking the court to please grant the state's motion.
And Your Honor, I would just like to say that, Ms. Perez was in fear for her life. She was trying to defend herself, and also that she has no priors.
I know. Okay. But based on this charge, I don't feel comfortable giving her house arrest. You're going to have to see the division judge tomorrow. That judge is going to have to decide if the first degree felony victim was shot, airlifted to the hospital. Right? The airlift, that's what it said.
It did, Judge.
Yeah, right, or trauma. And I'm granting the state's motion for pretrial detention pending final hearing, holding with no bond. You will see a judge tomorrow. That judge will set a final hearing on the state's motion for pretrial detention. Good luck to you.
Okay, well, Judge Glazer seems to be doing okay. Her sound, however, has crapped out, as it tends to do as we get towards lunchtime. Perhaps that court should consider switching to new Sapasa sound, and perhaps that would help that out. Let's go back to Michigan. Judge Elmore.
All right, you may take your seats. All right, we are back on the record now for the 28th Circuit Court here in Wexford County. And the next case is People of the State of Michigan versus Devin Jean Plum. File number is 25.
By the way, Barbara, thank you for gifting the membership. I forgot to say thank you. I appreciate it.
Appearances from counsel, please.
Joanna Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Plum. She appears by video. Your Honor, I'm having trouble standing up and sitting down, so I think I'm just going to stay on my feet. I don't want. I'll figure out some other way to get your attention if I need to add something.
No worries. All right. Thank you for letting me know. Ms. Plum joins us today via Zoom from the Wexford County Jail. Ms. Plum, are you able to see and hear us?
Yes, Your Honor.
Thank you. We are here today for a motion that has been filed by the defense to seek a modification of the defendant's bond. And I have received and reviewed not only that motion, but also the response filed by the plaintiff. I'll turn the floor over to Mr. Harrison. Thank you.
Indeed, Your Honor, there's no point in reading my motion into the record. It's pretty simple and direct. I just wanted to comment a couple of things and allow the court to make an appropriate decision here. I get frustrated with these situations in these matters with clients who have made a genuine effort to make some significant changes in their life, and they need a little bit of help to get there. And inevitably the response, and I'm not even suggesting that it's improper in any way, but the inevitable response is, well, look at what happened in the past. What Mrs. Carey failed to note is that Plum has been to prison a couple of times too. I don't know if that's terribly relevant to where she is right now, except to say that it is an event that occurred in her life. I think she's in a position right now. It's not, how should I say, the strongest possession case I've ever seen in my life. It is not a situation where she was directly implicated, it was only by association. And she is in a position where she needs to make the next step. She needs to get completely out of situations, circumstances, temptations, et cetera, et cetera, et cetera. It is critical that she obtain rehabilitation so she can get those skills that she's going to need to be successful in her recovery at this juncture. I don't need to go into a lot of detail because the court is already aware of a significant amount of the backdrop here, especially with regard to the residence of her parents and the identity of her parents and frankly of Miss Plum herself. I think it shows us a picture of someone who needs to make a change. This rehabilitation stint is the first step in that process. We'd like to get her there as quickly as we can. I don't want to delay that if we don't have to. That's how important I think it is to her in mounting this journey she'll have to undertake. Thank you.
You mentioned that you don't think there's, or again, reference, I don't know if that Michigan Rule 6.106 allows or suggests the courts will take a look at the nature of the evidence. I see that there was no preliminary examination.
There was.
There was?
There was. We just got the transcript today.
All right.
Court may have that. The allegation is such that the controlled substances that were found were not on her person. They were in a room that was apparently designated to be her room and in a vehicle with what we believe to be a cooperative party who informed the officer that she thought that was Miss Plum's bag or something along those lines.
Was there anything like identified within that bag, license, card, or?
The witness said that Miss Plum had put it in her car.
Okay. All right.
And that it belonged to her. Miss Plum.
Okay, I'm just trying to understand it. It's okay. But that had there been or had there not been some issue there? And you said that there was something found in.
Yeah, there was a significant amount of paraphernalia, I believe, found in a dresser in a bedroom.
Okay.
That, and again, I don't want to inflame Mrs. Carey, and I don't want to overstate or understate the evidence here, but a lot of it was based on past observation. That's quote unquote Devin's room.
All right. So what does she also mention that Ms. Carey is focused on what has happened in the past? Whether that's right or wrong, but what is new? So you mentioned there's something new. What is Ms. Plum doing that's new?
That's what I'm giving you is the new part is she wants to move forward. Yes, she does have a past. Yes, she did have significant issues with drug possession, drug use, controlled substances. At one point in her entire family was involved with controlled substances to the extent that they were all in jail together here in Wexford County. She has been trying and needs to get away from all of those associations.
Where was she living when this occurred?
His residence.
I'm sorry, what's the residence?
Her parents in Harrietta.
The Harrietta house. All right.
She was in the process of moving somewhere else. But yeah, I mean, that was what her Secretary of State records would say. So her driver's license would say that. All of that's true.
All right. So she was still living in the same place. And what was she doing for work? You have a job?
I don't think so, Your Honor.
Okay. All right.
You know what? I am going to sit down.
Okay, whatever you need to do. I understand. Ms. Carey, your response?
Well, thank you, Your Honor. I do rely heavily on my written response. I did take some time to do that. And I think frankly that the proofs will, I think they're frankly quite strong, but there was drug sales going on there. They obtained a search warrant and they searched the inside of the residence and found methamphetamine in her room. A lot of her, most of her, all of her belongings were still there. I can't say all, but a good amount of her belongings were still there. And I'm going to ask the court, obviously, to deny this motion for release to treatment. Ms. Plum does have a significant history, and I think we are allowed to look at that, along with the factors in MCR 6.106. Her criminal history goes back to 2010. She has a lengthy criminal history. She has prior possessions of meth, of cocaine, of marijuana on school property, of methamphetamine on school property. She has theft. She has assault, resist obstructive police officer, and operating while visibly impaired, and a couple other minor things. I don't have any information on her record of appearance or non-appearance. At this time, wasn't able to dig that deep, but I do believe she does have a history of substance use or addiction. And when I looked, I did ask MDOC regarding her prior treatment history, and I outlined that in my written response. She has been, in our notes, she has been more than once, several times, a couple times to residential treatment and quite a bit of outpatient treatment. And at the arraignment in district court, he said she had just gotten out of rehab.
She's still on parole? Because I know she had a prison sentence back in 2019.
She's still on.
I don't believe so.
All right.
I think her history does bear out her character and reputation for dangerousness. I think this in particular, especially methamphetamine, is quite dangerous. She's charged with possession of meth as a second and a habitual offender fourth. I know we can only use one of those, but that is quite serious. And I think, again, the probability of conviction is quite high. I don't have any indication as to her financial means, but it does not appear that she has employment at this time, or that she's really had stable employment ever. And the last pre-sentence report that I had, she had 8 employers from 2010 to 2019. There are no responsible members of the community that have been named to vouch for her. And I know she has a lengthy ties to Wexford County, but I don't think that necessarily is in her favor, given her history. So based on all that, Your Honor, I would ask the court to deny the motion for release to treatment. Thank you.
One moment as I just take a look here at some notes. All right. Mr. Harrison, anything further?
I have nothing further, Your Honor. Thank you.
All right. Well, first, there's been a bind over, so there's been some finding of probable cause by the district court. Second, the court is familiar with the defendant's prior criminal history. There is a detail of it here provided in the people's response. The court also, I'll note that on her last PSI, it mentioned that she had never completed probation or parole without violating, not once but multiple times. In fact, looking back here at her history, she's had a few bond violations where she has been on bond for one charge and then gets picked up on another charge. Also, she has an unimpressive work history where she went from job to job, sometimes was employed for a month or two, or a couple months, or maybe a couple weeks. And so she doesn't have much job history. She's living at the same place. The court is quite familiar with that residence as it's referenced in a lot of cases here, or at least several cases here in the past. I'll also note that she's had multiple stints at rehabilitation, either while in jail or prison, or through Catholic Human Services Recovery Network, the Jim Gilmore Center, local meetings at AA and NA, also programs down in St. Joseph County, both looks like in the jail. And I assume she had treatment while she was in prison system. So I've got a defendant. We have a defendant here who has a long history over the last 15 years. And she's quite young. I think she's what, 36 or so, I assume. 33, sorry. So a 33-year-old still living in the same house, which the court again has mentioned is familiar with. It's often mentioned in several criminal cases involving drugs. So she hasn't changed her habit, hasn't changed her locations, at least for that. When I say habit, I mean where she's staying. I obviously make no finding as to the facts here today. That's not what's before me, although I can take a look at it based upon what I've heard today. And of course, it was initiated by the conversation from the defense counsel, which is fair. That's what he wants. That's what he needs to do, is talk about the quality of the facts. And that's why I asked some questions. So again, I've got a defendant who has been on multiple stints of probation, a couple stints of parole, and has never completed probation successfully. Probation is relatively low. Correct, the last time she was before the court, she had a total of 105 PRV points. That's not counting the felony, the 2 felonies for which she was convicted for last time back in 2019. So that means that if she were convicted here, either by any means, she'd be facing at the very least a 10 to 23, or as a 4th habitual enhancement, 10 to 46. So we've got some likelihood of conviction. We've got a real problem with supervision, whether that's been on probation, parole, or on bond. Multiple stints at rehab, and is quite concerned. Thankfully, we do have programs at the Wexford County Jail through Catholic Human Services, but also the employment of a social worker there. And therefore, the court is denying the bond modification, as I find that there's not justified in this particular case. So, all right. Anything else today, Mr. Harrison?
I have nothing further.
Thank you. Anything further, Ms. Carey?
No, thank you.
All right. This case shall continue on the court's docket. I understand this thing, and thanks for Mr. Harrison letting me know that they just received the transcript. I hadn't seen it in the file yet.
I think it just rolled in this morning.
It must have. Again, I looked and there was nothing in it.
We don't have it yet either.
All right. Well, anyway, so that means we've got potential motions that can be filed. Maybe it's a motion for quashing a bind over or search and seizure. I don't know. But I trust that that will be the next thing to look at by the defense. Thank you. We are adjourned.
Okay, that was Yard Work Court. I think that's what we decided that sound was in the background. At first I thought it was like the Souls of the Dead, like it was a crossover from Dungeon Court. And that would have been fun to have a crossover event. We haven't been here in a while. Let's go to Adams County, Colorado, where they are doing bond court. Let's see what's going on there.
Ms. Abbott, do you waive any further reading and advisement?
I do.
All right, before we talk about bond, I am going to impose a protection order in this case. It is not charged as a domestic violence crime. It is not a Victims' Rights Act. These terms will apply. Term 1, 2, 3, 7, and 9. Conditions of the protection order, also conditions of any bail bond. Protected party in this case is Denise Peters, date of birth May 18, 1959. Be advised that if you violate this protection order, you could be subject to additional criminal charges as well as contempt of court charges. Anything on bond, Ms. Abbott?
Yes, thank you, Your Honor. I'm asking for the court to grant Mr. Peters a PR bond in this matter. He was recently referred to diversion in his other court date. That just happened on November 3rd. It does appear that there is also a pending divorce in this matter that was just filed as well. In looking through the allegations, it does not appear that any of the contacts with the home occurred when the alleged victim was present. And so I do think that that is a mitigating factor in this case. He is only a CPAT category 1 with a total points of 0, which is something we rarely see for a person. So I am asking for the court to grant him a PR bond.
Thank you. For the people?
It's a violation of a court order. I'm just asking the court to set bond and the recommended amount based on the behavior in the affidavit.
Thank you. Courts reviewed the affidavit as well as the CPAT. Bond will be set $1,000 personal recognizance. Your next court date is going to be December 15, 1:30 p.m. in the FAC. You will need to sign the protection order. Thank you.
Thank you very much. Thank you very much, Your Honor.
Ms. Peralta, are you back? Yeah, coming up. Now I'm ready on Ms. Peralta.
All right, court will call Ureli Peralta Acosta. This is 25M6480. Ms. Abbott, do you waive any further reading and advisement?
I do.
All right, before we talk about bond, I am going to impose a protection order. Find that this does involve an allegation of domestic violence and does include a Victims' Rights Act crime. These terms will apply. Term 1, 2, 3, 4, 5, 6, 7, and condition 9, which states conditions of the protection order, also conditions of any bail bond. Protected party in this case, Damian, D-A-M-I-A-N, last name. Wait, is that backwards? Is it Damian Carlos or Carlos Damian? Let me look. It is Damian Carlos. Date of birth November 5 of 04. Be advised that if you violate this protection order, you could be subject to additional criminal charges as well as contempt of court charges. Miss Abbott, anything on bond?
Your Honor, this is an agreed upon PR bond from the prosecution.
All that for that. My apologies.
That's okay.
Sorry. It looks like there is an agreed upon personal recognizance bond stipulation from the district attorney's office. So bond will be set at $2,500. However, it will be a personal recognizance bond. Next court date, December 1st, 1:30 p.m. in Division R for arraignment. You will need to sign the protection order. Thank you.
Relatively tame over in Adams County this morning. Let's go back to Judge Elmore, new contestant.
Sean Van Atmel, he's the agent from the Michigan Department of Corrections. In charge of the file today. Looks like Mr. Potter may have been on it one time, but actually so was Mr. Van Atmel back when the case was placed on the delay. All right, first of all, we'll take a look here and go over the new SIR 88 and the 145 and the 101. Mr. Wood, have you received a copy of the updated PSI? And if so, do you have any amendments, corrections, or objections to make to the content?
Judge, I have a change to be made to the restitution provision, and I don't think it's in the nature of allocution. I believe it's a change that needs to be made. Paragraph 15 of the recommendations, Your Honor.
Yes, sir.
It simply says you must pay child support and related expenses as ordered by the court. That's a phrase that has been passed down from MDOCs on these cases, so that's what most of the agents say, but it's not as complete as it needs to be. It should say you must pay ongoing child support and arrearages in the amount of $17,096.39. That's the current arrears. And then a sentence after the sentence that's there right now that says ongoing child support and arrearages must be paid through the Wexford County front of the court or the Michigan State Disbursement Unit.
Mr. Van Atmel, can you make those changes? Thank you. I think we also, and I'll turn back to Mr. Wood in just a second. I think we were originally scheduled back on November 10th, so we have to change the CFJ 145 page 1 to today's date, which of course is November 24th. All right, Mr. Wood, we are with you. Anything further that you believe needs to be amended or corrected?
Not at this point, Your Honor. No.
All right, thank you. One moment. All right,
Judge,
oh,
Judge, I apologize. Again, these are. I think it's a change that needs to be made, not just a allocution, but Judge, the liabilities section near the end of the report says there are no liabilities, and I mean that's all this case
obviously
is about.
that does not, yeah. Yes,
his liabilities. So his liabilities are ongoing child support in the amount of $310 per month. And again, a child support arrearage in the amount of $17,096.39. So that's what I would like the liability section to say.
oh, all right, thank you. Mr. Van Atmel can make that change. Which section are we looking at? Is that back in the old part? Because I don't know
yes,
if we covered that. Yeah, it would be back in the previous PSI because the update doesn't deal with that. That would have to be probably CFJ 284. Hold on.
Yes.
Mr. Van Atmel,
Page 10.
there we go. All right. So underneath finances on CFJ 284, page 10 of the previous PSI that was issued back on November 7th of 2004, we're just going to add that there are liabilities. Granted, it's already listed underneath the liability narrative, but we can address that. All right, thank you. All right, Mr. Hartel, any other amendments, corrections, or objections to make to the content of the report?
No, Your Honor.
All right, 1 second. I want to make sure I understood the Killebrew.
The Killebrew was for a delayed sentence, Judge, and
Yep.
he didn't meet the threshold for a reduction, so he's got the 2 counts of felony non-support. There's no Killebrew beyond that as to what we would ask for at this point.
I got it. I'm getting it. All right, thank you very much. So now I'll turn to allocution to the defense. Go ahead, Mr. Hartel.
Thank you, Your Honor. I would ask the court to consider this being a situation where there is no additional jail or probation. I believe that would be appropriate under the circumstances. My client, albeit has not met the threshold to get the benefit of the delay of sentence, but at least some payments were made. He does realize this debt, which is the best way I can think of to describe it, will continue. He will continue to owe the child support and the outstanding court costs. If he fails to do so, well, he'll be staying at the local county lodgings. And he is aware that these don't just go away. People do have arrears into the future. He's also, I'll even use this phrase, painfully aware that he's going to have the label of being a felon as a result of this conviction. Is going to influence him in all the ways that influences everyone else. Finding work was difficult before. It's going to be even more difficult for him. He's not going to be able to do the same level of hunting he used to enjoy, things of that nature. I do believe those punishments and the fact that this will continue to be owed are sufficient without any additional punishment. Thank you, Your Honor.
All right, Mr. Wood, allocution, sir.
Well, Judge, I know the recommendation is for straight probation, and you know, if Mr. Newell had been paying, I know as and it's correct that he's made some payments, but he's missed most months. I mean, since the initial sentencing back in December of last year, his $4,200 bond had already been paid in, and so that's in again December. He paid nothing, and I understand he's a cement contractor. That's our understanding, is that he has a business and he's only 36 years old. He's an able-bodied man by all accounts. But he paid nothing in January, February, March. In April, he paid $600. He paid nothing in May, nothing in June. In July, in the heart of his season, he paid $1,200, but he paid nothing in August, nothing in September, nothing in October, and nothing so far in November. It's unacceptable, Judge. He's got a 6-year-old child here that he's going to have to take care of for a long time. And he did pay his bond, so he got the benefit of the delayed sentence, but he did not do well during the delay, Judge. I'm thinking, Judge, I'm thinking it's the Monday before Thanksgiving. And I'm thinking that Mr. Newell maybe needs to spend the next period of time that you can choose in the Wexford County Jail. And he needs to be on probation. We're going to ask for 3 years. I know normally I'd ask for 5 years. I don't think that's permissible anymore. I don't know the exact requirements, but 3 years of probation. And again, some initial upfront jail, so he understands that this is serious and he needs to comply with the court's orders. But
can I give him jail on a felony on a felony non-support with an intermediate sanction scoring of 0 to 9 months?
Sure you can, Judge. I mean, he basically committed several felonies while he was on your delayed sentence. Yeah, each month he didn't pay is another felony. And yeah, there's no prohibition. Maybe probation can can pipe in about this? No, you could give him upfront jail.
Yeah, so, but what would you suppose my reasonable grounds be?
Because he's committed felonies while he was on a delayed sentence, and he did not comply with the underlying child support order. Judge, I don't think there'd be any problem with you imposing, again, I would suggest 7 days of jail starting now. And, so he doesn't wait till after Thanksgiving. And then again, this is a 6-year-old child that he's got to take care of for a long time, Your Honor.
Let me go back and address one of those comments. What was the felony that he committed while he was on a delay?
Well, Judge, I know it's the felony non-support statute, MCL 750.165 says, so that's the felonies he's committed, Judge. Each month he didn't pay. That's another felony. And again, we don't think of it that way, but yeah.
It was the way you said it. I thought maybe there was a felony that committed that I missed, but there hasn't been any new convictions while he's correct?
No new convictions.
Yeah. So, all right. So on the felony non-support, 1 second. So. To ask a question. 1 second. There we go. Sorry. So what I'm looking for is what are my reasonable grounds that would I can use today to go and rebut the reasonable presumption that he is to get probation and fines and costs only. Is there an exception for that on child support, or because typically there's an exception for crimes that are violent, like domestic violence, assault, battery, and so forth. So that's why I was looking at this concerned. I think it's 771.34, or no, 769.31B. That's what I wanted. Is there an exception to that? 769.31B that should have some exceptions. So I have to have reasonable grounds to be able to give somebody any kind of confinement. And so far as I understand it, underneath that section, I have not allowed to unless there is a certain exception. So that's my problem here.
I'm looking at 769.31B. Oh, this is 31.
Yeah. And then it's into 34. So 769.34 takes me to where an intermediate sanction must be imposed unless I have reasonable grounds. And I need to know, that's why I'm asking, what are my reasonable grounds? Now, there can be some exceptions here for violent crimes without finding reasonable grounds. But the problem here is it's an intermediate sanction. those in Lansing have told me, which includes the entire legislature, because it was almost overwhelmingly voted for by everyone back in 2020. I say everyone that held a legislative position and the governor told me that when there's an intermediate sanction, I am not to give jail unless I find reasonable grounds. Now, that makes it problemsome, and sometimes it makes it problemsome for me. And say a child support case, or actually even a variety of cases. Let's say it's an embezzlement from a car dealership. I don't have somebody from a victim coming in and saying, Judge, this is really, really hard because it impacted me because we couldn't pay wages, we couldn't pay salaries. Or here, if I had something, and by the way, I looked, there's no victim impact statement. If the victim had said, hey, I can't afford to pay for soccer games, or I can't afford to feed the child, then I'd have some kind of reasonable grounds. When I look here in the past, I don't see that. I see the defendant has been on, he's had a couple dismissals. I will say he had one case where he had a probation violation back in 2007. So I need to have some reasonable grounds, and I don't really know what they are, especially without a victim like a wife or the mother of the child being here.
I have to be honest with you, Judge. I've done a whole lot of these hearings. This is what when I retired from the division, from the AG's office, I was running this division.
Yeah.
And
trust me, I want to place a parent who is not taking care of their child. But this, I don't know when you were last in charge of this division,
right?
But 76934 became law back in 2020, took effect on March 24th of 2021. And this law says that when there's an intermediate sanction, such as in this case, I am not allowed to give any jail unless I'm able to find reasonable grounds. Now, when I find reasonable grounds, I can't take into consideration anything that was already used to reach the scoring, which means I can't take in his prior criminal history. I can't take into consideration the amount of money. I can't take into consideration the fact that he's got 2 convictions at the same time, because all those things are taken into consideration for finding reasonable grounds. And personally, I may not like this statute or how it ties the hands of the court, but so far it also hasn't been reversed or challenged in the Court of Appeals yet. So I need to know, I'm looking if is there a separate exception that applies to these kinds of offenses? That's what I really need to know. So,
well, Judge, if the law doesn't allow you to, again, while someone's on a delayed sentence, which is it's a matter of grace from the court, I can ask for it. You don't have to give it. I don't have to ask for it. You can give it anyway. We asked for it. You placed him on the delayed sentence, and then during the delay, he flaunted the court's order. I mean, he again violated the underlying child support order, and he committed, again, I could count them up. I think it's 7 or 8, maybe 8 or 9, because the way the law is written, when this project started a long time ago, back in the early 2010s, the AG tried to get the law modified so that there was a tiered, maybe a $0 to $1,000 in arrears is not a crime yet. Maybe 1 to 5 is a 93-day misdemeanor, 5,000 to 10,000 is a low, high court misdemeanor, that sort of thing. The legislature did not want to do that. Instead, the way the law reads is that each month that a person doesn't pay child support, a day late or a dollar short, is a new crime, is a felony. Yeah. And so he's on a delayed sentence that you placed him on. And during the delay, he commits 7 felonies. And I know he hasn't been convicted, but I don't hear any argument that he did pay. No, I was paying, they just didn't know it.
I got it. So, Mr. Wood, you are preaching to the choir. Here's another thing. Can I give somebody jail when they fail to pay fines and costs on probation?
Again, you have somebody from MDOC sitting there, and I understand that if there, you know, there's a distinction between a technical violation and a non-technical violation.
I know, but if somebody violates by not paying their fines and costs on probation, let's say he wasn't on a delay. Am I allowed to put somebody in jail merely when they are unable to pay unless somebody proves to me that he has the ability and chooses not? That's the key language.
Right. I'm familiar with that concept, Judge.
Yeah.
Absolutely.
Yeah. So,
yeah.
So
now the unique
here's
thing
my,
about,
go ahead, sir.
the unique thing about these cases is if he doesn't pay his restitution while he's on probation, again, that's a crime. And so, whereas normally not paying, not paying restitution, although again, there is still the provision where we've got to show that he, that he does have the ability, or it may be that he's got to show that he doesn't have the ability. That would make more sense. I know we've done some hearings like that.
Yeah, Mr. Wood, I completely agree. Everything you're saying makes so much sense, but the legislature and with the approval of the governor have told me that what you and I think makes sense is the law. There has to be proof that the defendant could afford to pay and chooses not to. Or I have to have reasonable grounds. And when I get to these hearings, by the way, prosecutors rarely ever bring in witnesses to tell me, here are the reasonable grounds, such as not having this money means I couldn't pay for this, I couldn't pay for that. I can tell you, I want to put deadbeat parents in jail. I need to have the legal authority to do so.
Judge, if the victim was there, how does that, where does that, I apologize, Judge, but where does that fit into the, you now have a reasonable basis?
You'll note that I began this conversation, and by the way, I'm doing this intentionally for a couple of reasons. But I first began by asking the question, where is the authority that allows me to do it? And unfortunately, there really isn't. Because 769.34 tells me I can't unless I have reasonable grounds, which means until someone presents something to me that allows me to find reasonable grounds, because there's another court rule, there's another statute here, and I think it's probably the 769.31, where if I find that the guidelines are inadequate, and that's the problem. This is one of those things where whoever enacted the statute may or may not have known what they're doing, but I assume they do. That's what the law tells me. I'm supposed to believe that they do. It says that I can find that the guidelines are inadequate and don't account for it. I could use that for reasonable grounds, but so far it's not presented to me. That's my problem. So, all right, here we go. All right, sir, Mr. Newell, you have the right to make a statement before the court issues a sentence. Is there anything you wish to add today, sir?
Yes, sir.
Yes, sir, go right ahead.
First of all, I apologize for what's going on here, and I've tried the best I could for the whole year on this probation thing. It's just been a struggle for me, and I'd like to, Mr. Woods here said that I paid in July $1,200, and I'd like to, it was $1,250. And each payment that I made was over $500. I understand that I have a $310 payment each month, but I simply couldn't make them. Life's a struggle right now for me, And I'd like to apologize. I'm sorry. Thank you.
All right. Court sentences the defendant as follows. The court places the defendant upon a period of probation for 36 months. I adopt the terms or conditions that are listed in the pre-sentence investigation report on CFJ 145. Page 2, continuing on to page 3, that includes the added change to the language on paragraph 15, which is term or condition 9 or 8.9. That is, the defendant is to continue to pay his ongoing child support and paying on the arrears, which are $17,090. I think they were $96.39. The defendant has the right to be considered for early release on probation at halftime if he's been compliant with those terms and conditions. I don't know here whether or not, I think all the terms and conditions are probably appropriate. Let me take a look here at the defendant's criminal history. Yeah. Court wants to ensure that the defendant is not using any kind of substances, but the random the testing is only if required by by the probation officer. The court is concerned though, because if there is an alcohol or substance use issue, whether it's marijuana or alcohol, the court wants to ensure the defendant is clear-headed so he's not missing it. Now, there's probably one thing here. Hold on, let me go through the fines and costs. So we had $268 state minimum fees, the $130 crime victim right front fee. I'm going to do the $300 court cost. I'm going to keep the fine at 0. The attorney fee again is $300. We probably did not need a DNA fee here. $30 is supervision per month, or $60 if there's any electronic monitoring. The big question here is what, if anything, can the court do for sentencing as far as any jail time? Well, I was looking for the argument. No one was able to provide it. At least nothing that really helps me understand this. How old, what year was the child born in? Does anybody want to tell me? 6 years ago? Yes. All right. So, is it just one? Yes. Okay. So,
Off and on, so work's been slow.
okay. Mr. Wood, I'm going to tell you, these rules and these statutes do not make sense when you, and this is what I'm trying to do today. I'm trying to highlight, at least as part of this 3-branch government as a judicial officer, maybe you as part of work, go and deal with this yourself. Job, but I can't use anything because no one's given me anything yet. By the way, if prosecutors were to decide to start showing up and presenting to me some more victim impact statements, maybe I could. So I give the defendant his 15 days in jail with 15 days of credit. Do I think a person who takes care of the child, should he or she go to jail? Yeah. But the legislature has told me that I can't, unless I have reasonable grounds. And I find that the guidelines are inadequate. So far, I have nothing that's objective. My only decision would have to be subjective. And I can't do that as a judge. That's not within my realm. I'm supposed to be, and I am, neutral when I'm sitting here. So anyways, all right, that is the sentence of the court.
The
Yeah.
delay, the fine, attorney fee and court costs were $100. Did you
Oh.
want to increase to 300 or leave it?
No, thank you very much. I'll just leave them because I really want him to be able to pay these fees off. I'm sorry, the child support. Thank you very much, Madam Clerk. So I've adjusted those amounts. All right. Trust me, Mr. Wood, you and I agree.
Well, Judge, I greatly appreciate the time you've taken to go through this process, because this is going to go up the chain of command here. Because I'm a little
perplexed,
say embarrassed that I know there's restrictions, but when someone commits a felony, that should certainly be an exception. And there should be exceptions. So I will look into this, Your Honor, and I greatly appreciate your time. And Mr. Newell should know that what the AG can do is, if he doesn't pay going forward, they can charge him again with felony non-support. If he isn't paying at least his ongoing support, that's a crime. And that's what the AG does in this division. So he needs to start paying his ongoing support at least.
I understand. Again, today, while two people may agree, I'm not a person, I'm a judge. So, Mr. Newell, you are receiving 2 copies of one document. You will place your initials on one copy. Doing so neither elects nor waives any rights. It merely acknowledges receipt of your copy of that document. This document tells you that you have the right to appeal the conviction and sentence in your case, and is typically done by filing what's called a claim of right to appeal. However, when there's a plea, the plea that reduces it down to you can only file what's called an application for leave to appeal. If you choose to file an application for leave to appeal, and you want the court to appoint an attorney to assist you, you may complete the bottom half and return to the court within 42 days. Do you understand, sir? All right, Mr. Newell, I know we've been talking around you a lot today. This is about you as a father. You got a kid out there who needs you. Maybe it's just money, I don't know, but let's focus on that. I know you're having a difficult time. I hope that you're taking jobs, even if it's something that's like you might think is below you, because when you're a father, nothing is below you. I don't care if it's picking up trash, working in a Christmas tree field, or picking fruits or vegetables someplace, or working in a yard.
Well, I've applied at a couple jobs recently within the last 2 weeks, just because I know it's getting towards winter and it's gonna be nowhere for me, you know what I mean?
Yeah.
So, just so you know, I'm trying.
Mr. Newell, keep it up. Keep it up. Work hard, okay? Thank you very much. We are adjourned.
Thank you, Your Honor. Thank you, Mr. Artell.
So I don't disagree with anything that went down there as far as holding this guy accountable, but I would propose something extra that happens in 0 jurisdictions in the United States. And that's that the parent who has custody is held to an equal standard of how they spend the money that they're given. In no jurisdiction that I'm aware of anyways, is that parent responsible for actually spending that money in a way that helps the child. And so often the money is wasted on things that have nothing to do with the child. So if there was ever a case for reform in anything that we see here at TCF, that one is towards the top of my list, because you're forcing this guy to do everything he can to be compliant. And I'm not saying that he shouldn't be compliant, but you're not holding the other side of that equation equally accountable. Just food for thought. Let me know what you think in the chat. Let's go back to Judge Mom.
Thank you for adjusting clerk relief for court. Counsel, today's the date scheduled for the arraignment and the pretrial. And as to the arraignment,
Wait for reading.
the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, and as to the pretrial.
Your Honor, my client's going to tender a guilty plea to a lesser included charge of operating negligently impaired.
All right, sir, please raise your right hand. You solemnly swear or affirm testimony about to give this matter be the truth, the whole truth, and nothing but the truth.
I swear.
Okay. And you heard the plea that was placed on the record, correct?
Correct.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights.
I do.
You also understand by entering into a plea that you'll be waiving some of those rights.
I do understand.
You've gone over the possible penalty as a result of your plea, whether in this court, any other court or administrative agency, correct?
Correct.
And knowing all of that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, they haven't.
Any immigration issues?
No, Your Honor. May I please have the date of the offense?
October 18th. And counsel, if you can please order your client.
Mr. Phillips, were you operating a vehicle in the city of Riverview on October 18, 2025?
Yes, I was.
Prior to operating that vehicle, did you have any alcohol?
Yes, I did.
Are you,
Oh, I'm sorry. Is you picking him up? Okay.
all right, and how much alcohol did you consume?
A fair amount, enough to blow 0.2.
All right, do you believe that alcohol impaired your driving by not being able to stay in your lane?
Yes, it did.
Testify, Your
And you stipulate to the .222, counsel?
Yes, Your Honor.
The court will accept the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge and dismiss the original charge per the plea agreement. As to bond counsel.
Your Honor, my client came in timely. He was very respectful. He's 32 years old and works as assistant manager at Applebee's. He lives in Westland. He doesn't have any children. He graduated high school in 2011. He's not on probation or parole, as indicated, with no pending cases. I asked for first one.
All right, sir, when's the last time you consumed any alcohol?
Not since I got arrested.
I'm sorry?
Not since I was detained.
Okay, and sir, you know at what level you're intoxicated because you have a prior from 2017. And have you ever failed to appear in court for any reason, sir?
I have not.
Are you on probation or parole anywhere?
I am not.
And are you out on bond in any other jurisdiction?
No, I'm not.
The court's going to continue your cash bond. The court's going to also order, sir, you to participate in random testing. Given the levels and given your previous conviction, the court wants to ensure that you're not going to possess or consume any alcohol or drugs that are not prescribed. So you're going to go over to probation, sir. You're going to get a copy of your bond conditions as well as your testing information and a whole slew of other information. Okay? All right. Good luck to you. We'll see you back at sentencing. Thank you. You have a good day. We're on the record in the matter of the City of Riverview versus Ethan DeLong, 251312.
Good morning, Your Honor. Mr. Shemke, apparently up my client who approaches.
All right. And sir, your name for the record, please.
Ethan John DeLong.
All right. And so this matter is adjourned because there was not a factual basis on the plea that was put forth previously.
That's correct, Your Honor. And then I was able to get the discovery from Mr. DePloy. I reviewed it with my client and had a dialogue with the prosecutor. Based on the evidence that was provided, my client is now prepared to enter a responsible plea to a lesser included civil infraction of careless driving and a guilty plea to the no insurance charge.
Okay, sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes.
Well, hold on. Mr. Carmen, your appearance for the record, please. Mr. Carmen. Can you message somebody out there, please, to have Mr. Carmen come in here? Mr. Carmen.
Michael A. Carmen, P73824, on behalf of the prosecution, Your Honor.
Okay, and so on the matter of Mr. DeLong, did you speak with the victim in this matter?
I did, Your Honor. I don't think his account of what happens matches the evidence, which I reviewed, the video and the photographs. That's why I'm offering civil infraction.
Okay, and so there's not any request for restitution then? Okay.
No, Your Honor.
All right, sir, please, did I swear you in?
Yes, Your Honor.
Okay. And so you heard the plea that was placed on the record, correct, sir?
Yeah.
As to the amended charge of careless driving, how do you plead?
Responsible.
As to the amended charge of no proof of insurance, how do you plead?
Guilty.
Responsible or not responsible?
Then Judge, I believe it's a no insurance, Mr.
Oh, I'm sorry, that was saying as charged. Okay. Oh. Sorry, I've white all over this thing here. As the no insurance, sir, how do you plead? Guilty or not guilty?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
You understand that there could be some additional sanctions from the Secretary of State.
Yes.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No, Your Honor.
All right, and counsel, if you can please write to your client as to the no insurance.
I'd like to direct your attention to August 28th, 2025. Were you operating a vehicle in the city of Riverview? And at the time, you're operating without any insurance on it, correct?
Yes.
Satisfied, Your Honor.
All right, did you pick him up on him? Okay. All right, the court is also satisfied the plea is knowing, voluntary, factually accurate. The court will accept your plea to the amended charge of careless driving and to the no insurance charge. And counsel, you're asking for immediate sentencing?
Yes, Your Honor.
And what would you like the court to know?
Your Honor, my client's not on probation or parole. He doesn't have in mind a knowledge of any significant prior criminal history. He is gainfully employed. He has a valid driver's license. Judge, in this circumstance, I'd ask him to be admonished with cost and fines and if necessary, payment plan. Thank you, Your Honor.
Sir, do you have valid insurance on your vehicle now?
I do not. I'm getting ready to sell it.
Okay, and how did you get here today, sir?
I got dropped off.
Are you for sure you got dropped off?
No, I drove.
That's what I thought.
Okay.
So, sir, you've already gotten in trouble once for driving without insurance. Why do you keep driving without insurance?
I'm getting ready to sell the vehicle.
That doesn't answer my question. You continue to drive without insurance. As mundane as you may think it is, as ridiculous as you may think it is, I don't know if you do or not, that this is a crime. The state of Michigan says it's a crime, sir.
Yes.
You have to drive a vehicle with insurance. If you get in an accident, insurance is supposed to help the other person if there's injuries or damage or whatnot.
Right.
Okay, or even yourself. So every time you're driving a vehicle on the road without insurance, you're risking a whole lot of financial liability, sir.
I understand.
But you seem to not care because you seem to keep driving without insurance.
I will get it as soon as possible.
Well, sir, this is from August 28th, and you still don't have insurance, and we're 3 months later.
I can get it today if you need.
Well, it's not about me needing it, sir. It's about you needing it to legally drive a car.
Yes.
If you can get it today, why haven't you gotten it over the last 3 months?
Financial issues. I can pull it out of my rent money and get it today.
Or, sir, how about not drive? Where do you work?
Tom's Family Auto Care. I have to drive for a living.
Does your employer know that you're not insured?
Yes.
So, sir, if you have to drive for a living, you don't drive without insurance. So I'm not sure how you're going to get insurance today without your vehicle, because you can't drive that vehicle out of this parking lot not having it insured.
I can do it online.
Okay. The court's going to order a $200 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $425 with a no insurance. $200 cost from the careless driving, for a total of $625. So given that you're going to go pay your insurance today, how much can you pay per month? What day of the month works best for you?
I can do $100 a month. 15th.
December 15th?
Yes.
Do you like giving money away, sir?
No.
Then stop driving without insurance, because that's what you're doing. You're giving your money away to the court. All right, make sure, do not drive out of this parking lot.
Yeah.
They will be watching you, so do not drive. You don't have valid insurance. We cannot let you drive without valid insurance. We cannot knowingly let you violate the law.
Thank you,
All right, thank you. Have a good day. We are recalling the matter of the City of Riverview versus Alicia Trombley, 251307.
Good morning, I'm in Police Ensemble Court, David Birch, some Mr.
All right. Good morning.
Good morning.
And your name again for the record, please.
Yes, Alicia Trombley.
Okay. And so, counsel?
Your Honor, it's the same plea agreement. I did speak to the prosecutor before today's date, so that was kind of, we had already arranged that. The only thing, and then I know it's up to you, Judge, but the only other thing that's not on the plea form, I know that it's honestly up to the court, but I know the people don't object to fines and costs only if the court's inclined, obviously, but he didn't put it on there. I just discussed it with him.
Okay, and so counsel, I need you to just, I understand it may be the same plea, but for the record purposes, I need you to place it on the record, please.
Yes, Your Honor. Your Honor, my client's going to, in exchange for a dismissal of the original count, my client's going to plead to an anti-count of disorderly conduct in this case.
All right, and so, ma'am, please raise your right hand again. Do you solemnly swear from the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
And you heard the plea that was placed on the record.
Yes.
And as to the amended charge of disorderly conduct, how do you plead?
Good.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes, I do.
And you also understand by entering into a plea that you'll be waiving some of those rights?
Yes.
You've gone over the possible penalty as a result of your plea, whether in this court, any other court or administrative agency?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No, Your Honor.
Counsel, if you can please vote to your client. Mr. Carmen? Just a moment.
Sure.
Mr. Carmen? Can you please ask Mr. Carmen to come back in here, whether on Zoom or in person, please?
Michael A. Carmen, P73824, about the prosecution.
All right, thank you. And counsel, if you can please vote to your client.
Yes, Your Honor. Your Honor, date and time, please. I'm sorry. Okay.
August 28th.
Thank you, Your Honor. Probably on August 28th, 2025, you were in the city of Riverview, is that correct?
Yes, I was.
And you were delivering food that day?
Yes, I was.
Okay, and to where?
To a
To a daycare
To a
center?
daycare.
Okay, and at the daycare center, there you removed a stroller that didn't belong to you, is that correct?
Yes, I did.
Okay. And obviously you walked, that daycare was open to the public, is that correct?
Yes.
Okay, all right. Judge, I know that's sufficient for the original charge, Judge. I don't know if the court needs additional information.
Court will accept the plea as knowing, or I'm sorry, counsel, Mr. Carmen, are the people satisfied with that factual
Yes, Your Honor.
basis or no?
People are satisfied.
The court will accept that plea as knowing, voluntary, and factually accurate. and dismiss the original 2 charges per the plea agreement. Ma'am, your attorney worked out a really good deal for you because quite honestly, I'm not sure why somebody would steal a stroller that doesn't belong to them and then resell it on Facebook. So counsel, I think for those reasons, I need to not go with immediate sentencing today and set this matter for sentencing.
Oh, okay. There's a little bit of extenuating explanation of what we can deal with that at sentencing, Your Honor.
Oh, you can go ahead and tell me now.
Your Honor, when my client was present at the scene, there was a variety of clothes and strollers, and they appeared to be for donation purposes. She asked somebody at the daycare if those items were allowed to be taken, and she took one of the items, not realizing that the person probably didn't have authority to say anything about it. But there were a bunch of items out for sale. Judge, she delivers there all the time. They know who she was. She actually met with the police officer in this case and handed the stroller. So it's kind of a weird set of circumstances. I see the court's look, and I understand that it's a weird set of circumstances, which is why we ended into a plea instead of setting a trial date. But I'm just saying, Judge, it was a little more extenuating than her trying to just secret the cart out of the daycare. So I'm just letting the court. So.
Okay, well, and the court would also think that if she is somebody that's been there and delivers there frequently, that, you know, especially having the stroller have the name of the child still on there might be a clue that that was not up for that, but we'll address that at sentencing. Okay.
Okay, thank you. Thank you, Judge.
All right, bond and conditions are continued.
Thank you.
Please stop over at probation, then you can coordinate that with your schedule.
Thank you, Judge.
All right, we are on the record in the matter of the state of Michigan versus Christopher Skelly, 251327.
Ready, Your Honor.
While we wait for that contestant to come up, I must say theft of a stroller is indeed new. You're right about that, Michael, in the chat. But it's Michigan. I'm surprised because they do weird things. I'm surprised it's not like theft of some kind of vehicle or something like that. Anyways, back to Judge.
Afternoon, good morning, we're still morning. All right, and thank you for addressing appropriately for court. Today is a date scheduled for sentencing on your client's plea to 2 amended charges. One is attempt controlled substance use. The other is attempt possession of controlled substance. And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, there are no additions or deletions. There are 2 minor corrections. One is that the report indicates that the pills in his possession belong to his grandmother. They actually belong to his sister. And the other is the location of his employment, which is actually Romulus.
Romulus, Michigan.
I'm sorry. Sister. Okay. Was it the sister's car?
No.
Okay. All right. Okay, and counsel, as to the recommendation.
We concur with the recommendation. I think the probation is appropriate in the circumstances. I'm sure he will probably earn the opportunity to be released somewhat early. They are recommending that he be granted the 7411 status. We're asking the court for the opportunity to take advantage of that. And he does understand that that will be completely within his purview, whether he gets that or not, depending on whether he complied with all the conditions. And he assures me that he will.
All right, and sir, if you were to test right now, what's in your system?
Nothing.
All right, and so counsel, it appears for some reason that only the attempt controlled substance possession is eligible under 7411 and not the attempt controlled substance use. Because it says only for count.
That is what the report says.
Right, and so I'm slightly confused on that. So sir, who are you helping get home from work?
His name's Damian Daughtry.
Oh yes, I think we've had that person here before. And so So you're helping the wrong person. So that person had the crystal meth?
I guess that's what it was. Yes, Your Honor. I didn't know the person. He was coworkers with my friend at the time. And I was helping my friend get home and he asked me to take him home too.
Okay, so I guess my question is this. Why does it matter? It says that the pill in the car belonged to your sister. And then, but then you're saying that you just helped the wrong person out. And then apparently it sounds though the pills belong to the wrong person.
It was one Tylenol 3 and it was for my sister. She has her own script for him because she had bad ear problem. And I can prove that.
That was in addition to the other junk stuff.
Yes.
Oh, in addition to the other stuff. Okay, that makes more sense. Well, what happened to your matter in 2016 out of Van Buren for felony dangerous drugs? Was that dismissed?
I never had anything with that. I don't know what that is. I've never. Yeah.
All right, so I'm not quite sure why this isn't showing eligible under count 1 or under count 2, because I believe that that is permissible under count 2. So I'm going to order, and I'm going to order this. And if for some reason it's determined that that this conviction is not eligible under count 2, then it would not be eligible under 7411. Okay. So, but counsel, does that change the plea that you have for your client?
No, Your Honor.
Okay. The court will note after hearing from counsel, hearing from Mr. Skelly, reviewing the report, the recommendation. That the court does find there's reasonable grounds to pardon MCL 769.5. The court also finds that the following sentence is in the best interest of justice, is reasonable and proportionate to the seriousness of the matter, taking into account the seriousness of the matter and the circumstances surrounding Mr. Skelly and the legislative guidelines. The court's going to order 18 months probation. You're eligible for early discharge. You're also eligible under 7411. And I'll go over the early discharge in just a moment. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, whether in person, in writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status, not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you can further assist yourself in providing coping mechanisms to maintain sobriety and hopefully prevent this matter from happening again. If you go to treatment and they indicate you don't need treatment, then they have to just submit something to probation. You're to participate in the fan meetings once per month. The rehabilitative goal for that condition is so that you can have this additional support to maintain sobriety and any recovery resources, as well as 5 days on the court workforce, each count of those. So it's a total of 10. The rehabilitation goal for that condition is to help you further develop life skills and give back to the community. Any questions regarding those conditions?
No, Your Honor.
The court's going to order as to count 1. The court's going to order a $500 fine, $100 screening assessment fee. Supervision oversight fee is $900. That's $50 a month at 18 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. Workforce is $200. It's 5 days at $40 a day. That's a total of $2,125 for count one. Count two, the court's going to order a $500 fine. I'm not ordering a screening assessment fee or oversight fee because it's the same case. I've already assessed it. $200 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, $200 for the court workforce. It's 40 days. Sorry, $40 a day at 5 days. So that's a total of $1,025. For a total between both of these of $3,150, which is a lot of money, sir. But just so you're aware, the maximum fine on count one is $2,000. And since it's an attempt, it cuts it in half to be $1,000. I charged you $500. And the possession or the controlled substance use max is $1,000. Attempt is half, so I gave you the $500. Okay, you're welcome. So I'm going to have you set up a payment plan with probation, and then, sir, as I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've been in good faith efforts or making full payment. Okay? Thank you. Have a good day. All right, let's go off the record for a moment. Do we have a lot of failed appears, or are there some people out there?
No.
Okay, these are the last two. Okay. All right. Let's go on the record in the matter of the City of Riverview versus Christian Grocky, 25R363061.
All right, looks like Judge is done. Let's go back to Judge Elmore. He has a new contestant.
All right, our next one is also Mr. Diegos, and it's People versus Miranda Bosack. This is file 25-14144 FH. We are here today for, it looks like, a plea in this. All right, do we have Miss Bosack here? She's in jail and Zoom. All right. Oh, I'm sorry. Miss Carey is here on behalf of the people. She's the Wexford County prosecutor. Mr. Diegos joins us today via Zoom, and Miss Bosack joins us today from the jail via Zoom. Ms. Bosack, are you able to see and hear us?
Yes.
Thank you. All right, we're here today for a plea. Ms. Carey, why don't you go ahead and tell me what the plea is?
My understanding is defendant will be guilty as charged.
Is that correct, Mr. Diegos?
It is, Your Honor. I'm also hoping that Ms. Carey would confirm that the prosecutor's office would not object 7411 if the court finds it appropriate at the time of sentencing.
Sure. Ms. Carey? All right. Ms. Bosack, would you please raise your right hand? Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You may lower your hand. Ms. Bosack, I'm told today that you're going to enter a plea of guilty as charged. Now, we're going to go over this and have it make sense. Before I do, Ms. Carey, do you know, is she eligible for 7411? I don't want there to be anything illusory.
I believe she is. I don't believe she has any record.
Okay, thank you. Ms. Bosack, do you have any criminal convictions of any kind in your past?
I have 2 driving with no insurance and 1 improper registration because it had overlapped.
All right, thank you. All right, Ms. Bosack, also back on November 10th of this year, were you on probation or parole?
No.
Thank you. Bosack, you are currently charged with a single count. That count is possession of the controlled substance methamphetamine. Now, that is a felony punishable by up to 10 years and or up to $15,000. I'm told that you're going to plead guilty to that offense. Now, you might wonder, well, what's the benefit? I'm going to talk about that in just a moment. But before I do, I need to tell you that if you enter a plea of guilty and I accept that plea, you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have to defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. Ms. Bozak, do you understand those rights?
I do.
And even more importantly, do you understand that if you plead guilty and I accept that plea, you will be forever waiving those rights as it applies to this particular case?
Yes, Your Honor.
Furthermore, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing an application for leave to appeal, not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim the plea were a result of any promise, threat, or inducement not told to me today on the record, or that the plea was not of your own free choice. Ms. Bozak, are you entering the plea of your own free choice?
I haven't been able to speak to my lawyer, so it's been a minute.
Okay. Well, we're going to place you into a breakout room right now and allow you that opportunity. Now, but before I do, let me go over just a few more things so you can speak to him about them. In Michigan, when it comes to sentencing and someone's convicted of a felony, there are what's called the Michigan Sentencing Guidelines. And they, while not mandatory, do provide to the court some guidance as to what the minimum end for your sentence would be. While I told you the maximum punishment is up to 10 years, based upon what you have told me, you would probably score, I estimate, this is not a promise, but I estimate you would be scoring approximately 0 to 6 or 0 to 3 months, which means that would be an intermediate sanction cell. And because you've never been on probation, or at least, have you ever been on probation?
No, Your Honor.
Because you've never been on probation and you haven't violated probation, there's probably no reasonable grounds that I could use to give you jail. Now, we've also talked about this other part of the pretrial agreement. Now, this one is a little tricky, but I want to explain it to you. It's an agreement that you've reached with the prosecutor, and it's about sentencing. It's something called 7411. Now, that number, 7411, is just a number of a section of law. And it says that if you are eligible, meaning you have never been convicted of a drug crime, I can place you on a delay of sentence. That could be up to 3 years. And if you complete that delay successfully without violating your terms or conditions of probation, the charge would be dismissed. Now, when we talk about a pretrial agreement with the defendant and the prosecution, I want you to think of 3 different shapes. The first one is just a line. It's a solid line between you and the prosecutor where you reach an agreement. And that's called a Killebrew agreement. Hold on, I got it. We're not giving one. I'm telling her what the differences are. Killebrew agreement, which is not being done here, would be that if I do not agree with the sentence and did not give you 7411, you would have the right to withdraw that plea. That's not being done here. The second shape is like a triangle. That's where I would agree today to place you on 7411. I don't do Cobb's agreement. That's called a Cobb's agreement. I don't do Cobb's agreements because I don't know anything about you other than what you told me today. I could come back here for court and we could find out that you've been on a killing spree around the world and have got aliases and you're wanted for assassinations. I don't know. Just I'm being silly for a reason. We're not doing a Cobb's agreement either. So instead, the last shape is like a dotted line between you and the prosecutor. And it just means that she's going to make a recommendation at sentencing that I place you on 7411.
I am not going to recommend that.
Oh, I thought you said, no, you wouldn't object.
Right.
Sorry, she's not going to object. Different. So now we've got nothing. We've got no agreement. That's a force shape, which is no shape. It doesn't mean that she's going to recommend it. She just is not going to object to it. So I just want you to understand that. Now, by the way, my likelihood of placing people on 74, no, hold on, that's the wrong way to say it. Statistically, if a person is eligible, I almost always put them on 7411. Ms. Carey, could you just ask before I let them take a break and do a conference? Can you tell me, is there any co-defendant in this case?
Yes, there is.
Is that the person we had in here earlier today? I just saw the long list of witnesses.
No, he is actually set for preliminary exam today in
Okay.
district court, or tomorrow, I mean.
All right, so also what I would expect, and Mr. Nagos, after he speaks with her, he might ask me to release her on bond with terms or conditions, which I might want to do generally, because I want to see if she's going to be compliant on bond and see how she does. Do you have any other issues there? Like, do I have to do a no, would I have to add a no contact order or something else? Because this looks like it says a GPS tether with house arrest. That kind of would lead me to believe that there's something more to it to make that.
There's a lot more to it, and
Uh-huh.
people would oppose a release right now.
Okay.
And there are some things that I frankly don't want to
Talk about.
All
right, thank you. All right, so you've heard a little bit of talk there, Ms. Bozak. Before I take a plea, before I continue, also in Ms. Carey, because it sounds like maybe there's not a lot of communication, and Mr. Carnes may have been the one handling it. Is there any other term or agreement like required testimony or anything like that?
No, this
Okay.
is my case. I've been handling it, and there is no.
Oh, I'm sorry. All right. That was the other file. I'm sorry. Thank you.
Yeah, no.
All right, good enough. All right, Ms. Bozak, my clerk here, or our clerk here, is going to put you and Mr. Nagos into a private breakout room. And we'll wait until he tells us that you come back. All right, thank you very much. We're in a temporary recess.
Okie dokie, here's another place we haven't gone in a while. Let's go to El Paso, Texas, and jail magistrate court. Let's not, because they just took that offline. All right, be that way, people. Let's go back to Judge McNally then. Let's do that.
All right, so you're gonna plead as charged, correct? To the charge failure to yield, responsible or not responsible?
I'm sorry, what did you say?
Responsible or not responsible to failure to yield?
Responsible.
I'll accept the plea 195. How much do you have today?
And I was trying to see if I can get 30 days to pay.
You work?
Yes,
Where do you work?
AAA life.
How about if I have you pay 50 per week? Can you do that? Or not?
Yes.
I'll tell you what, you pay 50 per week and I'll start this beginning December the 1st, okay? If you ever need more time, just call the court. We'll go on Zoom and I'll be glad to give you an extension, all right? Thank you. Good luck.
Well, he's between contestants. Wahoo, by the way, thank you for the gifted membership a few minutes ago. I very much appreciate that.
Your Honor, good morning. Courtroom, thanks to Elevate Thomas Smith, stating have some for sentencing, I believe.
Your name, ma'am? So she just fired her lawyer. He withdrew. She didn't want to represent her.
So she's asking for a 2-week determination.
She's asked me that before and I'm gonna do it, ma'am, but this is it, okay? So I asked adjourn 2 weeks. Lisa, what day are we gonna?
Do you want it on a prosecutor day?
There was no accident. I don't really need it on a prosecutor day, to tell you the truth.
Okay, December 8th at 8:30.
Okay, December the 8th at 8:30. So I just want you to know, I've adjourned this from October 29th to November 12th, to November 24th, December 8th. No more adjournments, okay?
Okay.
All right, have a nice Thanksgiving. We'll see you here on December the 8th. Thank you.
Thank you.
Thank you, Mr.
I'm telling you. Jamie Ferguson. 25T646810. Defendant failed to appear. Default judgment center. What's your name, sir?
It's 10:45.
Oh, okay. Okay. How you been doing?
Good, Judge, how are you?
Yeah.
Ready for Thanksgiving?
Yeah. I just.
Just show up.
Yeah.
Literally.
Yeah.
You good, John?
Yeah, yes, all set, thank you.
Are we all set or?
Yeah, I got nothing for you.
Day or what? It should be there with.
Yeah. Yeah, you should be on some, that was.
Happy Thanksgiving.
Have your Thanksgiving. All right, I'm good. All right, we'll see you.
Are you, so this is it? You're taking off? You're done?
The boss tells me.
Okay. Have a great Thanksgiving, dude. Take care.
See you.
All right, let's go back to Judge Elmore. It looks like they're continuing where they left off.
Ms. Bozak, I had told you what the charge was. I had told you what your rights were. I told you how by pleading guilty, you'd be waiving those certain rights. I asked if there had been any other promises, threats, or inducements, which I don't believe there were. Are you entering the plea of your own free choice today, Ms. Bozak?
Yes, Your Honor.
All right, thank you. Now, when it comes to the sentencing, when I talked a little bit about it and tried to give you an idea of how it would work, the question I have for you though right now is, has anyone promised you or asserted to you exactly what the sentence would be?
Did what?
That's all right. If I didn't say it clearly enough, I apologize. Has anyone made any promise to you as to exactly what the sentence would be in this case? All right. Now, any discussion, whether it's about guidelines like what I discussed earlier or in your conversations with Mr. Nagels, those are strictly estimates and guesses and trying to help you understand how sentencing works. Do you understand that?
Yes, Your Honor.
Do you still wish to enter the plea of guilty as we discussed earlier?
Yes, I do, Your Honor.
As to the single count, how do you plead?
Plead guilty.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. So, turning your attention back to the date of October 10th of 2025, out in Herring Township, here in Wexford County. What happened, Ms. Bozak?
I was in possession of methamphetamine.
Where were you at the time, or how did you get caught with it?
There was a search warrant issued at my residence.
All right. And was that residence out in Herring Township?
Yes, Your Honor.
And was some methamphetamine found there in your residence?
Yes, Your Honor.
Now, was there anyone else residing with you at that residence?
Yes, there were other people that resided at that residence.
All right. So the reason why I asked that question is because I need to ask a little bit more about how you possessed this methamphetamine. So where was the methamphetamine that you possessed to which you're pleading guilty to? Where was it found?
In my camper, Your Honor.
In your camper. Okay. And did you know that it was in that camper?
Yes, I did, Your Honor.
And did you have the right to possess and or control the methamphetamine that was found on that date in that camper? Oh, I'm sorry. Let me go back and ask it. So to be able to establish possession, either you owned it or you had it in your possession, which means you also had the right to control it. Did you have it within your possession, whether right on you or in the camper, which you had control over?
Yes, Your Honor.
All right, thank you. In your mind, did you have any lawful right to possess that controlled substance, methamphetamine?
No, Your Honor.
And again, you knew that it was methamphetamine.
Yes, Your Honor.
Do you know how much it was? How much it
No, Your
weighed?
Honor. No, Your Honor.
All right, so when I ask this question about possession, because I know that there are things out there that often get charged like residue cases. What was this methamphetamine in?
It was in a baggie, Your Honor.
And so if you were to hold that baggie up, could you actually see it?
Yes, Your Honor.
All right, thank you. That just tells me that it wasn't like a residue that you couldn't see, so you actually had knowledge that it was there. Thank you. Ms. Carey, do you believe she's provided a factual basis?
I do.
Are you aware of any other promises, threats, inducements?
I'm not.
And do you believe the court's compliance with Parole 6.302?
Yes, sir.
Mr. Nagos, do you agree with all three of those?
I do, Judge. Thank you.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the offense. Therefore, she is found guilty of count one. Ms. Bozak, we will be back here for sentencing, and that's typically in about 4 to 5 weeks. It depends upon the holiday schedules of all those that are involved. Between now and then, an agent from the Michigan Department of Corrections, which is also known as the Probation or Parole Office, must prepare a pre-sentence investigation report. This report will describe the pretrial agreement, describe the facts of the case, include information about you that you will provide to them. It will also include a scoring of the guidelines, which again are not mandatory, and it will include a recommendation as to the sentence, which is also not mandatory. Preparation of this report requires 3 steps that involve you. Number 1, you will receive a packet at the jail. You'll open it up, follow the instructions, complete all the information to the best that you can, and then turn it back in. The second is you'll be subject to an interview with an agent from the Department of Corrections office, and you have the right to have your counsel present at the time of the interview. And third, prior to coming back to court, you and your attorney will meet to go over the contents of that report, as each side has the right to appear before the court and ask for corrections, make objections to the contents of the report, as we must make sure that it is complete and accurate before the court uses it to establish a sentence. Do you understand, Ms. Bozak?
I do, Your Honor.
Thank you. Ms. Carey, anything further on behalf of the people?
No, thank you.
Mr. Nagos, anything further on behalf of the defendant?
Yes, Your Honor. Briefly, I'm not sure if the court would hear me on bond or if Ms. Carey would waive notice.
Hold on. I'm willing to hear it. However, I turn to Ms. Carey. Ms. Carey, do you waive notice?
Well, I'm going to object to it, and typically I would waive notice, and I don't want to be difficult, but in this particular case with
I don't need to know the
so
facts.
much going on, I'm not going to waive notice.
So we'll have Mr. Nagos, if you choose to file a motion to have the court reassess it, please do so. But according to the court rules, specifically court rule 2.119, there must be notice. So I will wait to see what happens. All right. Thank you very much.
Yes, Your Honor. Thank you.
All right, friends, a couple minutes early, but I think that's a logical place to leave it for today. I hope you all had fun. More court than I thought there would be. There are a lot of courts I know that will not be in session this week, but that's okay. We have lots of choices here at TCF that we can make. So we'll be back tomorrow at 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. I would again like to point out that we have our Black Friday sale running over at courtroomfiles.com. Please do check that out. We've launched a bunch of our Christmas merch. We have more coming. We also have a wonderful calendar for 2026 that I think you'll all love, so give that a look. a sale for the public, 15% off of everything at the store right now. There is a code displayed on the website to get you that. Members, you get 25% off, and that is posted in members only areas on Discord and on the community tab. So please check that out. Look forward to seeing you all tomorrow. Go have yourselves a great Monday. Take care. God bless.